If you go on the side, that'll be better, please.
Like over there, is that okay?
Perfect.
Okay.
Thank you.
That's okay. How about down here on the end? What do you think?
Welcome to Zoom for Government. Enter your meeting ID. Enter your participant. Please enter the meeting passcode. You have joined the meeting as an attendee and will be muted throughout the meeting. The host would like you to enter. You are unmuted. You are muted.
Silas Rankins, I think. I got an email from Mark saying what the name said.
Let me see.
25.
Oh, thank you.
Is this the red one?
Oh, you know what? One.
Oh, you have an extra one?
Yep. I don't have an extra one, but I'm not going to need it.
Karen?
Nope, has to be up. So we get going, then you can put it on.
Yeah.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. I'll take the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Morning, Your Honor. Adam Miley for the
Good
Commonwealth.
morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCCA. So I think I told counsel before that I had reviewed, so first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the Sidebar conference and read that transcript, and I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at Sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at Sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this Sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So. right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolfe. So I'll hear you on that.
Thank you, Your Honor. May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolfe should be stricken in its entirety. The subject matter of Dr. Wolfe's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolfe will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolfe to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, is cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolfe is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolfe is qualified to talk about the manner of death. Dr. Wolfe invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, one paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his findings, it says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolfe has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolfe fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolfe. And I want to note and this is Fractures of the Classification and Clinical Features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolfe, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information. But it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolfe, because we're not given one example of where Dr. Wolfe, before his report, his one-paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolfe has explicated in his report. And I will conclude with 2 points. Dr. Wolfe says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy, and we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolfe uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts, it's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolfe from testifying in matters beyond his kin, and in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman, it's the same with other experts, where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the 2 prongs of the Dalbert inquiry?
All right, thank you. Mr. Brennan?
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolfe's credentials. Dr. Wolfe is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolfe has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolfe was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4 He's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. His book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on the journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon, who has this extraordinary experience, is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolfe is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolfe treats patients that are in trauma, who some survive and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolfe's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. LaPosada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. LaPosada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with countercoup, having treated tens of thousands of patients, and he understands in countercoup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of countercoup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolfe, and I would suggest that he's more than qualified.
All right, thank you. Mr. Leslie, anything final?
Yes, thank you, Your Honor. Mr. Britton. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible, of Dr. Wolfe is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolfe's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolfe's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes just to focus on manner of death, let's assume hypothetically that Dr. Wolfe is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did, because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolfe. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolfe's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolfe, and it's not addressed in terms of the one paragraph that we have. And for something as significant as this, one paragraph that doesn't address common acceptance, methodology, Daubert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not one instance where we see that Dr. Wolfe has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like...
We attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence.
Did she adopt it? Was there... Okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead. I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall...
So let me just have... So you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity, or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
There'd be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
And so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't. But what's the nature? Is this something?
The court will call this. This deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass. There were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time,
No,
right?
this is more attendant to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
Do you have the day of her testimony?
Gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it, and she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence. What matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its submission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there. But also, it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case, and I say that because we learned last night for the first time on a public airing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that, and also there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony, or statement rather, statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so Mr. Jackson, what I'm going to do is just hold off. Hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. It's just, I need to hear more of the evidence
I
again.
understand, and
And I'm going to read the transcript, so that will help me with
I think it
this.
makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind.
Sure,
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great, thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited, this argument will be limited to the, we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the Qualls, Binns, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statement relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it, but in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So, Mr. Brennan, you can have a seat again, and we'll go through the defendant's one. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood, thank
All
you.
right. All right, so that was 559. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view,
Okay.
okay, but let's talk about your client attending it.
Yes, Your Honor, there was a request in there for Ms. Reeve to attend. That is something that's allowed under the law.
How do you propose that's done?
If it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus, if the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions, and I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposals. So I need more information from both. So, Mr. Brennan, I'd like you to come up with a proposal about viewing the car a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place, if that's what we decide. We may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right, so let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend, so let's figure out some particulars. All right, so defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry. 562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but, so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. He or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right, so obviously is not something that should be in a motion, okay? If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted, okay?
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right, so you all need to talk, all right? And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given, okay? All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government, and certainly I would have a right to try to ask the court or insist that they should be sequestered, but I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite on basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should not be able to attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address Sidebar because it is subject to a protective order, but I would like to make a record.
But I'll take a closer look at both of these and have something later. All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay?
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted at least with limitations, obviously, time limitations and subject matter limitations by the attorneys would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to impanel a fairer and more comprehensive jury.
Okay, what's the Commonwealth's position?
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow, so I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. You know, I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we've got a backbone to start with.
So let's do that. What Mr. Brennan's new to the case, what I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So, is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. .570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. And the very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." in some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others consider, an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened, it serves to visit an extreme and an extraordinary prejudice against Ms. Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable cause standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27th is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believed, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community or these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be very easy.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Ms. Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another, walking into court and basically lambasting the defense, for all intents and purposes, about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, which is, or the defense has, which is just not true. So we would ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Kearney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Kearney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at their family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr.
I
Jackson.
just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aidan Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly. But let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. We could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief, and we will be very mindful of what would conceivably open a door to this kind of testimony, and I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar, and I think that could resolve the issue.
Okay. Thank you. I'm going to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first, and we would respond, including with regard to our motion.
Okay. So, Mr. Brennan, our paper 386, your number 12.
Your Honor, paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion in retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth vs. Hanley, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Lassie.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable, and here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up in ipsy dixit and saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states 2 paragraphs under the chart with an asterisk. The ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion in that statement, there is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas chromatography or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All
It
right.
should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
Can I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing now for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk? All right, so what I'll do is I'll see counsel at Sidebar regarding scheduling.
rise for the court, please.
You are muted.
We'll be recessed 15 minutes.
Boy, I can feel the breeze from that fan out here. Good morning, everybody. Welcome to Dedham, Massachusetts. Michel Bryant here for Justice Serve TV as we continue the saga that is the Karen Reed case and the death of Officer John O'Keefe. The drama. You know, I want to get into a little bit of the last-minute filings that took place yesterday on St. Patrick's Day. The court obviously taking no holiday that day because there's some interesting new motions filed. But let's start with the very beginning from today. And before I get into this, the Aidan Kearney hearing that was going to be at 9 o'clock this morning in Stoughton has been moved to noon. I talked to Aidan this morning about that. It's his impression that it'll be quick. It'll be an arraignment. It is not as likely to be a bail revocation, which kind of was on the table, meaning he'd have to go back to jail. We don't think that's going to happen. He doesn't think that's going to happen, but it is still hanging over his head. You can check that interview out when we get done with our little update here during this break. But let's talk about the first thing that happened this morning. You know, the judge, she likes her drama. Let's put it that way. So she takes the bench, and she is exercised. She is breathing heavily. She is so concerned because she has determined, and let me see if I can get some of my notes here because it was dramatic. It sounded like she was on the verge of either yanking one of the defense attorneys from the case or prohibiting the ARCCA experts from testifying, because what she found in her research, in her review of all the moving papers, in her review of the transcripts, that there had been, wait for it, let me get some of the exact language here, because it was critical. She found intentional misrepresentations by the defense, found it to be deliberate. The defense counsel suggested there was less to the relationship between the defense and ARCCA experts than was reality. And she said, July 2024. But in February, the 26th of 25, just a few weeks ago, they said there had not been any direct connection. And this caused her such concern. I was really concerned for her health. But she made it sound like, you know, the hammer's going to fall here. And in a very interesting maneuver, she has the defense team and specifically the defendant herself, Karen Reed, come to the bench so she can decide how she's going to handle this in terms of sanctions. That was how she phrased it. Let's figure out the sanctions. Commonwealth, sit down. Don't worry about it. We're going to handle this. So they have a sidebar with this ominous cloud hanging over the proceedings, hanging over the defense, hanging over the trial of this thing that's set to start in 2 weeks. And then she comes down with her decision, which was really to do nothing. She asked Karen Reed if she wants to proceed with the attorney she now has, which, of course, there's lots of. Oh, hey, there's Dina.
Hi, everyone. Make sure you hit the like button because this channel's awesome.
Dina is going to come back during the lunch break, aren't you? You're going to come back at lunch break?
I think so. You're going to Stoughton?
I'm going to run to Stoughton after we do this, and then I'll come back.
Okay, when you come back, because I'm probably going to stay here.
Okay, yeah.
Hi, everyone in there. Hi, Missy. Hi, Lulu. Hi, everybody.
Aidan's telling me he thinks it's just going to be a quick arraignment in and out, that they aren't going to try and cuff him and haul him away.
Honestly, in my personal opinion, and this is only my personal opinion, I don't think they're going to take him in because there's a lot of people filing wiretap charges against Chris Albert, and I sort of think they're probably going to wash this one away. Okay. You know,
you heard that. I was there yesterday making my recording, so I'm sure I have a complaint as well. So,
all right, I'll let you get back to your thing, but I'll talk to you
lunch.
guys later. Bye. Free Karen Reed, free Turtle Boy.
All right. So anyway, so we'll talk to Dina more at lunch when we get to that lunch break. So the judge is all exercised about this. Candor is the most important thing with the court. And, on and on and on. Ultimately, does nothing. She asked Karen Reed, are you happy with your attorneys? Do you want to maintain those attorneys? Of course, she says yes. What's she going to do? Pick somebody to throw overboard? Of course not. And then the secondary question was, okay, well, is this going to impact then the ARCCA experts? Are they somehow going to be prohibited from testifying? No. So it was a lot of whoop-de-doo, a lot of drama for nothing. The judge ultimately does nothing, which, in my opinion, was the right decision anyway. But why all the drama? Oy. Anyway, I think flagrant violation was another phrase she used. So the Pro Hoc Vice crew plus Mr. Yannetti, all in place. That ain't changing. Moving on. Okay. And so before we get into some of the last minute motions from last night, let's hit some of the high points from this morning. And again, we've just got whatever it is, 10, 15 minutes before they head back in. The first one was the motion by the Commonwealth to exclude Dr. Wolfe. Remember, there are a couple of Dr. Wolfes in this case. This is the doctor that was going to talk about the cause of death and the manner of death. And Mr. Alessi's point was that to support their motion to exclude that testimony, that there is no methodology. Remember, under Lanigan, Daubert, there has to be methodology, and then that has to be accepted within the relevant community, etc. But he says it doesn't matter because there is no methodology. There's nothing listed in the incoming.
I just got some news. So anyways, they're gonna break for the day for Karen's at noon, I was just told. So probably everyone's gonna head over to Aidan's. And they'll be done for the day here.
So that was the scheduling conference they were just having, right?
Most likely it was. So that was just told to me that it's ending at noon.
Okay,
All right.
Thanks. We'll see you later. Yeah, so you're going over there then, right? Okay, we'll set up over there then. Okay. All right then. So that kind of truncates today's activities, which is unfortunate. But I think it's interesting that the court is basically acknowledging the important nature of the case going on up the road in Stoughton, and it's just a few minutes away. It's no big deal. But you think this courtroom is small? You think this building is big or small? This looks like twice the size. I went by the Stoughton District Court yesterday. It looks to be about half the size of this court. So while I was hoping to kind of sneak in there thinking, hey, this is going to be less publicized, people are going to be all over here. Tough to tell now because the whole caravan apparently is going to be moving over to Stoughton. So anyway, this Dr. Wolfe was going to talk about, among other things, and still may be able to, because of course the court did not rule, about the fall backwards. How, his opinion was that John O'Keefe fell backwards. Well, there's no basis for that opinion. So how can the court allow that opinion without the basis for that opinion? The manner of death and the cause of death, sometimes confused, both very important. This expert was supposed to testify as well about the ground being frozen. Well, there's certainly no basis for that, not his expertise last time they checked. And as to the manner of death, Alessi points out that even the autopsy report doesn't have a manner of death. And this expert is a neurologist, if you believe the Commonwealth, not just a neurologist. No. He's a neurosurgeon, having done thousands of operations. I do find it was interesting how Brennan characterized this gentleman's work as having worked on living patients, but a lot of them died. Yeah, a lot of these guys died, which gives him apparently some additional expertise on cause and manner of death, despite not being an ME, medical examiner, not being a forensic pathologist. Yeah, a lot of his patients died. So that gives him some additional street cred, I suppose. And so it is Brennan's position that this guy is better than an ME. He's better than a forensic pathologist because he is a neurosurgeon that has worked on a lot of folks and apparently lost a number of patients. Okay. One of the key issues is, and this is a fun word if you want to look it up, contra coup, C-O-N-T-R-A-C-O-U-P. This has to do with the brain, lack of a better phrase, sloshing around in the skull. And it happens when you fall on one side of your head and the brain smacks into the opposite side of your skull. So you fall to the ground, hit the back of your head, the brain smashes into the front of your head, causing this contra coup type injury. That is going to be an issue with this expert. Again, if he's allowed to testify, I would bet that he is going to testify. Alessi, in his final words, was saying, hey, again, there is no methodology. You have to have methodology to your opinions. This guy has none. I then again noted how Brennan popped up one more time to say that this neurosurgeon has had a lot of people die. So he knows better than most MEs about death. Okay. Then they talked about number 558, if you're keeping track of this on your scorecard, 558, the demonstrative exhibit question, or the chalk, because Massachusetts is, in the Stone Ages on a lot of things, including whether they call a demonstrative exhibit a chalk, apparently because they used to be written in chalk, not more permanent in terms of an exhibit. Key difference, of course, a demonstrative exhibit doesn't go in as evidence, is not going to be something the jury can look at after the case is submitted to them. It's really just designed to help them understand what the hell's going on. And this one relates to the testimony of Christina Hanley. This is the woman who will testify about all kinds of pieces of glass that were found, more than a dozen, I believe, where they found them, when they found them. And the defense just wants some sort of, flow chart, roadmap, so that the jury can understand how these things happened and, according to this witness, and how they all fit into the puzzle, because it was so confusing. If you remember her testimony last time, it was just downright confusing. And so, of course, there's no real argument by the Commonwealth to keep this out as a demonstrative exhibit. And so that's kind of how it was left. It's going to be allowed as a demonstrative exhibit with this witness's testimony. Then they'll revisit it at the time of her testimony to determine whether it becomes actual evidence or not. Next one up was the bad character propensity evidence. This was the Sullivan sisters. Remember the whole trip to Aruba and some flirting and some extracurricular activities. Apparently, the Commonwealth says we're not going to get into that. They also talked about the view. Now, remember last time, I always thought this was weird. They took the car, the subject SUV, to the site, 34 Fairview, and they parked it at the street curb, kind of where it was that night, depending on which testimony you believe, kind of between the mailbox and the flagpole, and that's where it was parked without its right rear tail light. And when the jury went for their view, they saw the car there as well, just sitting at the curb. So asking for a jury view, not a big surprise since they did it the last time, but they've tweaked it a little bit. The defense wants Karen Reed to be there as well. Now, she wasn't there last time. And that's not unusual. It's not unwieldy. It's not that tricky. Obviously, you don't throw her on the bus with jurors like it's a field trip, but it is a field trip, and she just gets there different in a different vehicle. And there's no back and forth between any of the parties, any of the jurors. This is a very quiet visit just to give the jury spatial orientation, because there's so much that allegedly happened at that scene and with that vehicle. Here's another wrinkle, though. The Commonwealth, remember, Brennan's now in charge, and Mr. Lally didn't seem to have a problem with it. I thought it was weird to have the car there. And Mr. Brennan is now saying, Judge, we're okay with the view. He didn't really even object to the defendant being there. But he said, we don't want the car there. We don't want the SUV there. If they're going to look at that, it should be at a different location. Hey, maybe they'll look at it at the Sally Port. That's a place I'd like to go hang out. Let me go to the Sally Port, check out those the cameras and that figure, the orientation there of the different things that the jury sees by video. Yeah, that would be more helpful, perhaps, even than going to 34 Fairview. So we'll see how that works out. I think the logistics to get Karen Reed there, not a big deal. But whether or not they allow the car at the scene, I think that's going to be very interesting. They talked about family members and experts in court. They're fine-tuning who is or isn't going to be allowed in court prior to testimony. And even after all testimony, there was some objection that the Commonwealth didn't want some witnesses to be there even to attend closing arguments. Well, first of all, the place is so tiny. I don't know how many folks can get in there to attend closing arguments. But that's how concerned the Commonwealth is about witnesses and their impact on a jury. This is going to be interesting. And I asked Aidan about this, if they were going to ask for some sort of exception that would allow him, because he's on the witness list now, allow him to watch the trial, whether in person or by video, so he can report as he has been. We know that his name being put on the witness list may have been done, just to handcuff him and never intend to call him. That's possible. We don't know. As the trial plays out, we'll find out one way or the other. We know his name came up already in the context of these motions in limine, that his connection with Karen Reed was critical to a lot of the events that took place prior to trial one and then during trial one. The other thing that came up tonight, today I thought was interesting, was last night's investigation discovery show. I think it's called Body in the Snow. I think they cleverly captioned it. A lot of interview with Karen Reed, with Alan Jackson, and the Commonwealth is citing some of the things she said in that show last night as things that they had never seen before. Specifically, she talked about how she had a drink in the SUV, and that Officer John O'Keefe took that glass and carried it with him when he left the car. That was something new the Commonwealth had never heard before. And so they're watching it, but they're picking that apart, and they're using that in some ways, they think, bolster their case and perhaps suggest that Karen Reed once again has changed her story or has contradicted something that she's on the record about prior. Let's see. And you may have noticed when I talked to them this morning as they wandered in, she did not watch that show last night because she had something better to do. I have a feeling somebody was watching it on her behalf and may have given her some of the high points. Okay, let's talk about the voir dire. Okay, there was a request by the defense that there be a panel voir dire. We know once they get it down to individuals that they will have, the attorneys will be able to question them individually. That's pretty normal. Last time, remember, there was a 2-page questionnaire, which I'm not going to call up here because I don't think we have time to get into it in too much detail. But that's how they handled the panel voir dire last time. It was with the questionnaire. And I'm not sure the defense wasn't okay with doing that again, but they wanted to bring a specific motion to make sure they handled the issue. Commonwealth doesn't seem to have a real problem with it, so they're each going to submit 1-page potential questionnaires. Again, not unusual. And then what they'll probably do is blend that, where there are overlaps, that's easy. But if there are distinct questions the Commonwealth wants, distinct questions the defense wants, then they will blend those under the court's purview and come up with the questionnaire that this panel will see. And we hadn't heard numbers, but Judge Bev did suggest it's going to be a lot. Be a lot of potential jurors called in. I can't imagine why. Just because everybody on the planet has heard about this case, is talking about this case, and has opinions about this case. Let's see. Oh, there was I thought this was interesting. This was the talk about the defense being concerned that during certain testimony of certain witnesses, initials Jen McCabe, that they make snide comments or negative comments toward the defense or toward Karen Reed or toward others that have said things to them. And Alan Jackson specifically mentioned a point at which during his examination of Jennifer McCabe, that she volunteered that some social media person had been harassing her. And she basically made it sound like, you know who that is, Mr. Jackson, and it's your fault, meaning the defense team, meaning the defendant. And that's highly prejudicial. And so Alan Jackson is trying to kind of cut that off at the pass. That became a back and forth about who opened the door. The judge said, well, wait a minute, I prohibited that last time, but you opened the door, Mr. Jackson. Once again, she's interrupting him on and on during the course of his various arguments. It's amazing how many interruptions. But anyway, you opened the door, Mr. Jackson. He said, well, I really don't think I did. I can't remember that. But they're going to follow that same process. There will be a prohibition against some of these collateral statements being made. And unless the door is opened, and Mr. Jackson has told the court, I will ask for guidance. If I think I'm getting close to, quote, opening that door, I'm going to ask the court for guidance to kind of keep me from doing that. We'll see how that plays out. I don't expect that to play out anywhere near as smoothly as Mr. Jackson suggests. I think if it happens, it's going to happen. And the court ain't going to step in to keep it from happening. Let's talk about, this is a Linda Kenny Bodden special, so I'm not going to get into it in too much detail. The blood draw. Remember, there's been a big fight about the method used to draw the blood of Karen Reed, which was about 6+ hours after the incident. Remember, I think it was at 7-ish in the morning. This happened at 12:30-ish. And what they're trying to do, of course, is take the blood 6+ hours later, do their magic mumbo jumbo, and come up with a blood alcohol level retrograde at the time of the subject incident. Because remember, one of the 3 charges is an alcohol-related charge. And so the defense is saying, well, this blood draw is a joke. There's no methodology. The hospital was not accredited to do this. And how they do this testing is just kind of fly by night. It wasn't done in the context of a criminal matter. They call it an OUI, operating under the influence. So they said it wasn't even done with that in mind. So we can't use that to extrapolate what the blood alcohol level was at the time of the incident. I fully expect this is going to be denied as well. Once again, taken under submission. But it came in last time. It's going to come in again, and then it's going to be up to the defense to poke holes in it with the reasons they give in their motion to leave it out, in which is not the proper methodology, not properly taken. It is interesting. I think that that the Commonwealth said, well, you heard the testimony from Dr. Fowler, I think it was. He's the one who laid the foundation for it all the first time. And, Jackson said, well, you can't rely on that. Well, guess what? I think it's just a lame kind of, argument just to make an argument. If he was allowed to do it the first time, Dr. Fowler, to come in to lay the foundation for the collection of the blood, which was then used to extrapolate BAC, blood alcohol at content at the time of the incident, he's going to be allowed to do it again. I mean, that in my mind it just ain't going to change. There was a motion, number 574. There was a motion limiting to exclude some prior bad acts or prior criminal history of Richard Green. Nobody's going to talk about that according to the parties. So whatever that was, that is not coming in. Hold on a second. One more note here to look at. And this is from last night. So that's all that's going on today. Let me bring you up to speed on where we are. So here we are, thinking this is going to be a full-blown day of 30-some motions in limine. We made our way through a handful. And no, that they had a scheduling conference just before this break, and now they're going to call it at noon, and that just happens to be at or about the time of the Aidan Kearney hearing, just up the road. It's maybe it's less than 10 miles. It's not that far, but I'm going to get broken down here, head over there, so we can talk later about some of the motions that were filed just last night. The court is going to call it here at noon, and then pick up tomorrow and hope to get everything in tomorrow. So now all the focus is going to shift to Stoughton. That's where Aidan Kearney is facing his 17th charge. This one related to the D&E Pizza event from the 4th of March. Or was it the 5th? 5th. I think it was the 5th. I was there. I just can't remember. And I was there yesterday just to check out. The cameras are still there. We don't know if they're still collecting audio because Mark Betterow, the attorney for Aidan Kearney, sent a letter to the chief of police saying, isn't it a violation of the wiretap laws if, this camera is recording audio and there's no notice that says it's recording audio? Well, there ain't no notice there anymore. I don't know if it's recording or not. The cameras are still there. So that is the basis for the arraignment in Stoughton. We're going to see what happens there. So I'm going to leave it with you. I know that Linda Kenny Bodden is en route, so we will pick this up a little bit later in the day today. Don't forget, Dina will pop on. I guess she'll be in Stoughton now as well. So we'll all pack up this road show, head to Stoughton, and then rejoin after that hearing and kind of bring you up to speed on where we are with that, as well as what's going on here in Dedham. So other than that, not much going on. So thanks for joining. I'm Michel Bryant. Hang with us as we kind of plod through the rest of the day, and Linda Kenny Bodden will join, and we'll get into some of these things in more detail. Until then, I'm going to check out from Dedham. We'll see you here in
all ahead. You might want to come over this way. There's a camera guy.
Ms. Reed, did you watch the program last night, the ID show?
Did not.
No interest?
Got more important things to do right now. Got a lot of work. Let's go.
Mr. Jackson, I know you're gagged, so can you tell me who you're wearing?
Got it.
We ain't got no quit!
Okay, so good morning, sir. Good to see you again. Okay, so thanks for your note last night that said the hearing was changed, because I would have been over at Stoughton right now, waiting for you. So what happened? How'd that all evolve?
Tim has a conflict, and he was involved with today or something. You know, lawyers say about their client. I'm not his only client.
No, I can't believe it.
Yeah,
Okay. So that's going to be at noon.
Yeah.
Any hints as to what to expect there?
Hopefully it's in and out arraignment. I mean, that's what they've told us it was in writing. They said that, my lawyers said that he had a conflict today, and if it's going to be a long thing with a bail revocation, that he needs to reschedule. And Cosgrove said we anticipate it being kind of in and out, and it's going to be, he's going to ask for the same conditions he asked at my bail hearing a couple weeks ago, or whatever that was. Hopefully he sticks by his word and we're in and out.
Yeah, that's got to be a sigh of relief, right?
Yeah, I mean, I'll believe when I see it. Obviously I'll feel a lot better. A much bigger sigh when it's over. Because what if he pulls a fast one? What if he tries to revoke my bail? It's like, obviously I'm on edge about that. So, I won't feel like myself, I guess, until that comes and goes.
Saying it over your head, I get that. Yeah. I was over at D&E Pizza yesterday, not getting pizza, and oh well. Let me just spin around here and.
The NX? Oh yeah. I test drove that one. I like that. Good morning. You guys look great on TV yesterday. Thank you very much, Will. You too. Likewise.
Is that the electric one? Is that the electric one, that car? Is that the electric one?
No. It's just like a smaller version of RX. Better on gas, cheaper, but
right.
doesn't drive the same.
So today's a mess. I mean, there's a lot going on. You think they're going to get through everything today?
No. I think it's going to be a 2-day thing. There's a million motions together. So hopefully we'll see what happens. It's a lot on the docket.
Hey, for the question about Mark, and I know I saw Will's extravaganza yesterday, and Mark was on there for quite a while, just trying to hit all the high points of what's happening here. What, if anything, do you think is behind the whole put you on the witness list, which we talked about last week?
No, it's to keep me out of the courtroom and to keep me from even watching the trial, talking about it. It's just an underhanded shot at the First Amendment. That's all that is.
Are you going to try and get some sort of exemption from that so that you can watch the trial?
I don't want to say too much about what our legal strategy for that is, but I intend on being able to watch and cover the trial in the normal capacity that I would. So that's the goal.
Okay. Thanks, man. Good luck.
Nice to see you.
You too. All right, so welcome back in Canton, and I'm sure you know where we are here, of course. Let's see if I can jaywalk without getting run over. There, of course, see at McCarthy's, and right next door is the B&E Pizza and Subs, which of course is the subject of the very interesting camera issue, right? So let me cross the street here. Hey, made it. And the question becomes whether this camera up here in the corner, is this camera up here in the corner? Up there? Is that capturing my audio? Could be. How you doing, folks? And if so, is that a violation of any sort of wiretap? Here's the other camera. This one you can see is inside. Hard to believe that has any audio pickup. Maybe it does, but certainly this one on the outside must. So again, Mark Betterow, the attorney for Aidan Kearney, has said, look, that's a wiretap violation because you need it's a two-party state here in Massachusetts. I need to be able to say okay, and anybody being recorded needs to be able to say okay. So that's the real question. Very interesting question, I must say. Let me wander on down the street here. Continuing down the street, because I was just over here at the waterfall of Voir, which is, we've made this walk before, just down the street. And I'm going to set up there and do a little something. I think Will, you know, the glarer, he's got a Karen-a-thon underway. And it's going for, I think he said 12 hours. The guy's crazy. But I'm going to try and join him to do that. By the way, Justice Serve TV, of course, will have the hearing tomorrow in the Karen Reed case. All the motions in limine will be streaming that, commenting on it. I'll see if I can grab some guests and we'll chat with them during the various breaks in the day. And then, of course, Linda Kenny Bodden will be joining as well in the afternoon. So hopefully you'll be with us for that. Oh, look, check this out.
Court's back in session. May be seated.
All right, so Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there is a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes,
okay.
Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right, do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right, thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan?
Thank you.
Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works, so why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown, and the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss at a final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
Our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. Months and months ago, we got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure. All right. So we'll see everybody back here tomorrow, but Thursday morning at 9 o'clock. That'll give you time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
It will, thank you, Your Honor.
Okay, so we'll see you Thursday. All right, thank you, everybody.
All rise for the court, please.
Goodbye.
I got it. Don't get too close. I don't want to get you sick.
I know. I know. I know.
Okay, all right.
Thank you.
We'll be recessed 15 minutes.
Boy, I can feel the breeze from that fan out here. Good morning, everybody. Welcome to Dedham, Massachusetts. Michael Bryant here for Justice Serve TV as we continue the saga that is the Karen Reed case and the death of Officer John O'Keefe. The drama. You know, I want to get into a little bit of the last-minute filings that took place yesterday on St. Patrick's Day. The court obviously taking no holiday that day because there's some interesting new motions filed. But let's start with the very beginning from today. And before I get into this, the Aidan Kearney hearing that was going to be at 9 o'clock this morning in Stoughton has been moved to noon. I talked to Aidan this morning about that. It's his impression that it'll be quick. It'll be an arraignment. It is not as likely to be a bail revocation, which kind of was on the table, meaning he'd have to go back to jail. We don't think that's going to happen. He doesn't think that's going to happen, but it is still hanging over his head. You can check that interview out when we get done with our little update here during this break. But let's talk about the first thing that happened this morning. You know, the judge, she likes her drama. Let's put it that way. So she takes the bench, and she is exercised. She is breathing heavily. She is so concerned because she has determined, and let me see if I can get some of my notes here because it was dramatic. It sounded like she was on the verge of either yanking one of the defense attorneys from the case or prohibiting the ARCCA experts from testifying, because what she found in her research, in her review of all the moving papers, in her review of the transcripts, that there had been, wait for it, let me get some of the exact language here, because it was critical. She found intentional misrepresentations by the defense, found it to be deliberate. The defense counsel suggested there was less to the relationship between the defense and ARCCA experts than was reality. And she had dates. Do you remember July 2024? But in February, the 26th of 25, just a few weeks ago, they said there had not been any direct connection. And this caused her such concern. I was really concerned for her health. But she made it sound like, you know, the hammer's going to fall here. And in a very interesting maneuver, she has the defense team and specifically the defendant herself, Karen Reed, come to the bench so she can decide how she's going to handle this in terms of sanctions. That was how she phrased it. Let's figure out the sanctions. Commonwealth, sit down. Don't worry about it. We're going to handle this. So they have a sidebar with this ominous cloud hanging over the proceedings, hanging over the defense, hanging over the trial of this thing that's set to start in 2 weeks. And then she comes down with her decision, which was really to do nothing. She asked Karen Reed if she wants to proceed with the attorney she now has, which, of course, there's lots of. Oh, hey, there's Dina.
Hi, everyone. Make sure you hit the like button because this channel's awesome.
Dina is going to come back during the lunch break, aren't you? You're going to come back at lunch break?
I think so. You're going to Stoughton?
I'm going to run to Stoughton after we do this, and then I'll come back.
Okay, when you come back, because I'm probably going to stay here.
Okay, yeah.
Hi, everyone in there. Hi, Missy. Hi, Lulu. Hi, everybody.
Aidan's telling me he thinks it's just going to be a quick arraignment in and out, that they aren't going to try and cuff him and haul him away.
Honestly, in my personal opinion, and this is only my personal opinion, I don't think they're going to take him in because there's a lot of people filing wiretap charges against Chris Albert, and I sort of think they're probably going to wash this one away. Okay. You know,
you heard that. I was there yesterday making my my recording, so I'm sure I have a complaint as well. So
all right, I'll let you get back to your thing, but I'll talk to you guys later. Bye. Free Karen Reed, free Turtle Boy.
All right. So anyway, so we'll talk to Dina more at lunch when we get to that lunch break. So the judge is all exercised about this. You know, candor is the most important thing with the court, and on and on and on. ultimately does nothing. She asked Karen Reed, are you happy with your attorneys? Do you want to maintain those attorneys? Of course, she says yes. What's she going to do? Pick somebody to throw overboard? Of course not. And then the secondary question was, okay, well, is this going to impact then the ARCCA experts? Are they somehow going to be prohibited from testifying? No. So it was a lot of whoop-de-doo, a lot of drama for nothing. The judge ultimately does nothing, which, in my opinion, was the right decision anyway. But why all the drama? Oy. Anyway, I think flagrant violation was another phrase she used. So the Pro Hoc Vice crew plus Mr. Yannetti, all in place. That ain't changing. Moving on. Okay. And so before we get into some of the last minute motions from last night, let's hit some of the high points from this morning. And again, we've just got whatever it is, 10, 15 minutes before they head back in. The first one was the motion by the Commonwealth to exclude Dr. Wolfe. Remember, there are a couple of Dr. Wolfes in this case. This is the doctor that was going to talk about the cause of death and the manner of death. And Mr. Alessi's point was that to support their motion to exclude that testimony, that there is no methodology. Remember, under Lanigan, Daubert, there has to be methodology, and then that has to be accepted within the relevant community, etc. But he says it doesn't matter because there is no methodology. There's nothing listed in the incoming.
I just got some news. So anyways, they're gonna break for the day for Karen's at noon, I was just told. So probably everyone's gonna head over to Aidan's. And they'll be done for the day here.
So that was the scheduling conference they were just having, right?
Most likely it was. So that was just told to me that it's ending at noon.
Okay, thanks. We'll see you later. Yeah, so you're going over there then, right? Okay, well, we'll set up over there then. Okay. All right then. So that kind of truncates today's activities, which is unfortunate. But I think it's interesting that the court is basically acknowledging the important nature of the case going on up the road in Stoughton, and it's just a few minutes away. It's no big deal. But you think this courtroom is small? You think this building is big or small? This looks like twice the size. I went by the Stoughton District Court yesterday. It looks to be about half the size of this court. So while I was hoping to kind of sneak in there thinking, hey, this is going to be less publicized. People are going to be all over here. Tough to tell now because the whole caravan apparently is going to be moving over to Stoughton. So anyway, this Dr. Wolfe was going to talk about, among other things, and still may be able to, because of course the court did not rule, about the fall backwards. His opinion was that John O'Keefe fell backwards. Well, there's no basis for that opinion. So how can the court allow that opinion without the basis for that opinion? The manner of death and the cause of death, sometimes confused, both very important. This expert was supposed to testify as well about the ground being frozen. Well, there's certainly no basis for that, not his expertise last time they checked. And as to the manner of death, Alessi points out that even the autopsy report doesn't have a manner of death. And this expert is a neurologist, if you believe the Commonwealth, not just a neurologist. No. He's a neurosurgeon, having done thousands of operations. I do find it was interesting how Brennan characterized this gentleman's work as having worked on living patients, but a lot of them died. Yeah, a lot of these guys died, which gives him apparently some additional expertise on cause and manner of death, despite not being an ME, medical examiner, not being a forensic pathologist. A lot of his patients died. So that gives him some additional street cred, I suppose. And so it is Brennan's position that this guy is better than an ME. He's better than a forensic pathologist because he is a neurosurgeon that has worked on a lot of folks and apparently lost a number of patients. Okay. One of the key issues is, and this is a fun word if you want to look it up, contra coup, C-O-N-T-R-A-C-O-U-P. This has to do with the brain, lack of a better phrase, sloshing around in the skull. And it happens when you fall on one side of your head and the brain smacks into the opposite side of your skull. So you fall to the ground, hit the back of your head, the brain smashes into the front of your head, causing this contra coup type injury. That is going to be an issue with this expert. Again, if he's allowed to testify, I would bet that he is going to testify. Alessi, in his final words, was saying, hey, again, there is no methodology. You have to have methodology to your opinions. This guy has none. I then again noted how Brennan popped up one more time to say that this neurosurgeon has had a lot of people die. So he knows better than most MEs about death. Okay. Then they talked about number 558, if you're keeping track of this on your scorecard, 558, the demonstrative exhibit question, or the chalk, because Massachusetts is, in the Stone Ages on a lot of things, including whether they call a demonstrative exhibit a chalk, apparently because they used to be written in chalk, not more permanent in terms of an exhibit. Key difference, of course, a demonstrative exhibit doesn't go in as evidence, is not going to be something the jury can look at after the case is submitted to them. It's really just designed to help them understand what the hell's going on. And this one relates to the testimony of Christina Hanley. This is the woman who will testify about all kinds of pieces of glass that were found, more than a dozen, I believe, where they found them, when they found them. And the defense just wants some sort of, flow chart, roadmap, so that the jury can understand how these things happened and, according to this witness, and how they all fit into the puzzle, because it was so confusing. If you remember her testimony last time, it was just downright confusing. And so, of course, there's no real argument by the Commonwealth to keep this out as a demonstrative exhibit. And so that's kind of how it was left. It's going to be allowed as a demonstrative exhibit with this witness's testimony. Then they'll revisit it at the time of her testimony to determine whether it becomes actual evidence or not. Next one up was the bad character propensity evidence. This was the Sullivan sisters. Remember the whole trip to Aruba and some flirting and some extracurricular activities. Apparently, the Commonwealth says we're not going to get into that. They also talked about the view. Now, remember last time, I always thought this was weird. They took the car, the subject SUV, to the site, 34 Fairview, and they parked it at the street curb, kind of where it was that night, depending on which testimony you believe, kind of between the mailbox and the flagpole, and that's where it was parked without its right rear tail light. And when the jury went for their view, they saw the car there as well, just sitting at the curb. So asking for a jury view, not a big surprise since they did it the last time, but they've tweaked it a little bit. The defense wants Karen Reed to be there as well. Now, she wasn't there last time. And that's not unusual. It's not unwieldy. It's not that tricky. Obviously, you don't throw her on the bus with jurors like it's a field trip, but it is a field trip, and she just gets there in a different vehicle, and there's no back and forth between any of the parties, any of the jurors. This is a very quiet visit just to give the jury spatial orientation, because there's so much that allegedly happened at that scene and with that vehicle. Here's another wrinkle, though. The Commonwealth, remember, Brennan's now in charge, and Mr. Lally didn't seem to have a problem with it. I thought it was weird to have the car there. And Mr. Brennan is now saying, Judge, we're okay with the view. He didn't really even object to the defendant being there. But he said, we don't want the car there. We don't want the SUV there. If they're going to look at that, it should be at a different location. Hey, maybe they'll look at it at the Sally Port. That's a place I'd like to go hang out. Let me go to the Sally Port, check out those the cameras and that figure, the orientation there of the different things that the jury sees by video. Yeah, that would be more helpful, perhaps, even than going to 34 Fairview. So we'll see how that works out. I think the logistics to get Karen Reed there, not a big deal. But whether or not they allow the car at the scene, I think that's going to be very interesting. They talked about family members and experts in court. They're fine-tuning who is or isn't going to be allowed in court prior to testimony. And even after all testimony, there was some objection that the Commonwealth didn't want some witnesses to be there even to attend closing arguments. Well, first of all, the place is so tiny. I don't know how many folks can get in there to attend closing arguments. But that's how concerned the Commonwealth is about witnesses and their impact on a jury. This is going to be interesting. And I asked Aidan about this, if they were going to ask for some sort of exception that would allow him, because he's on the witness list now, allow him to watch the trial, whether in person or by video, so he can report as he has been. We know that his name being put on the witness list may have been done, just to handcuff him and never intend to call him. That's possible. We don't know. As the trial plays out, we'll find out one way or the other. We know his name came up already in the context of these motions in limine, that his connection with Karen Reed was critical to a lot of the events that took place prior to trial one and then during trial one. The other thing that came up tonight, today I thought was interesting, was last night's investigation discovery show. I think it's called Body in the Snow. I think they cleverly captioned it. A lot of interview with Karen Reed, with Alan Jackson, and the Commonwealth is citing some of the things she said in that show last night as things that they had never seen before. Specifically, she talked about how she had a drink in the SUV, and that Officer John O'Keefe took that glass and carried it with him when he left the car. That was something new the Commonwealth had never heard before. And so they're watching it, but they're picking that apart, and they're using that in some ways, they think, bolster their case and perhaps suggest that Karen Reed once again has changed her story or has contradicted something that she's on the record about prior. Let's see. And you may have noticed when I talked to them this morning as they wandered in, she did not watch that show last night because she had something better to do. I have a feeling somebody was watching it on her behalf and may have given her some of the high points. Okay, let's talk about the voir dire. Okay, there was a request by the defense that there be a panel voir dire. We know once they get it down to individuals that they will have, the attorneys will be able to question them individually. That's pretty normal. Last time, remember, there was a 2-page questionnaire, which I have. I'm not going to call up here because I don't think we have time to get into it in too much detail. But that's how they handled the panel voir dire last time. It was with the questionnaire. And I'm not sure the defense wasn't okay with doing that again, but they wanted to bring a specific motion to make sure they handled the issue. Commonwealth doesn't seem to have a real problem with it, so they're each going to submit 1-page potential questionnaires. Again, not unusual. And then what they'll probably do is blend that, where there are overlaps, that's easy. But if there are distinct questions the Commonwealth wants, distinct questions the defense wants, then they will blend those under the court's purview and come up with the questionnaire that this panel will see. And we haven't heard numbers, but Judge Bev did suggest it's going to be a lot. Be a lot of potential jurors called in. I can't imagine why. Just because everybody on the planet has heard about this case, is talking about this case, and has opinions of this case. Let's see. Oh, there was I thought this was interesting. This was the talk about the defense being concerned that during certain testimony of certain witnesses, initials Jen McCabe, that they make snide comments or negative comments toward the defense or toward Karen Reed or toward others that have said things to them. And Alan Jackson specifically mentioned a point at which during his examination of Jennifer McCabe, that she volunteered that some social media person had been harassing her. And she basically made it sound like, you know who that is, Mr. Jackson, and it's your fault, meaning the defense team, meaning the defendant. And that's highly prejudicial. And so Alan Jackson is trying to kind of cut that off at the pass. That became a back and forth about who opened the door. The judge said, well, wait a minute, I prohibited that last time, but you opened the door, Mr. Jackson. Once again, she's interrupting him on and on during the course of his various arguments. It's amazing how many interruptions. But anyway, you opened the door, Mr. Jackson. He said, well, I really don't think I did. I can't remember that. But they're going to follow that same process. There will be a prohibition against some of these collateral statements being made. And unless the door is opened, and Mr. Jackson has told the court, I will ask for guidance. If I think I'm getting close to, quote, opening that door, I'm going to ask the court for guidance to kind of keep me from doing that. We'll see how that plays out. I don't expect that to play out anywhere near as smoothly as Mr. Jackson suggests. I think if it happens, it's going to happen. And the court ain't going to step in to keep it from happening. Let's talk about, this is a Linda Kenny Bodden special, so I'm not going to get into it in too much detail. The blood draw. Remember, there's been a big fight about the method used to draw the blood of Karen Reed, which was about 6+ hours after the incident. Remember, I think it was at 7-ish in the morning. This happened at 12:30-ish. And what they're trying to do, of course, is take the blood 6+ hours later, do their magic mumbo jumbo, and come up with a blood alcohol level retrograde at the time of the subject incident. Because remember, one of the 3 charges is an alcohol-related charge. And so the defense is saying, well, this blood draw is a joke. There's no methodology. The hospital was not accredited to do this. And how they do this testing is just kind of fly by night. It wasn't done in the context of a criminal matter. They call it I think they call it an OUI, operating under the influence. So they said it wasn't even done with that in mind. So we can't use that to extrapolate what the blood alcohol level was at the time of the incident. I fully expect this is going to be denied as well. Once again, taken under submission. But it came in last time. It's going to come in again, and then it's going to be up to the defense to poke holes in it with the reasons they give in their motion to leave it out, in which is not the proper methodology, not properly taken. It is interesting. I think that that the Commonwealth said, well, you heard the testimony from Dr. Fowler, I think it was. He's the one who laid the foundation for it all the first time. And, Jackson said, well, you can't rely on that. Well, guess what? I think it's just a lame kind of, argument just to make an argument. If he was allowed to do it the first time, Dr. Fowler, to come in to lay the foundation for the collection of the blood, which was then used to extrapolate BAC, blood alcohol at content at the time of the incident, he's going to be allowed to do it again. I mean, that in my mind it just ain't going to change. There was a motion, number 574. There was a motion limiting to exclude some prior bad acts or prior criminal history of Richard Green. Nobody's going to talk about that according to the parties. So whatever that was, that is not coming in. Hold on a second. One more note here to look at. And this is from last night. So that's all that's going on today. Let me bring you up to speed on where we are. So here we are, thinking this is going to be a full-blown day of 30-some motions in limine. We made our way through a handful. And no, that they had a scheduling conference just before this break, and now they're going to call it at noon, and that just happens to be at or about the time of the Aidan Kearney hearing, just up the road. It's maybe it's less than 10 miles. It's not that far, but I'm going to get broken down here, head over there, so we can talk later about some of the motions that were filed just last night. The court is going to call it here at noon, and then pick up tomorrow and hope to get everything in tomorrow. So now all the focus is going to shift to Stoughton. That's where Aidan Kearney is facing his 17th charge. This one related to the D&E Pizza event from the 4th of March. Or was it the 5th? 5th. I think it was the 5th. I was there. I just can't remember. And I was there yesterday just to check out. The cameras are still there. We don't know if they're still collecting audio because Mark Meadow, the attorney for Aidan Kearney, sent a letter to the chief of police saying, isn't it a violation of the wiretap laws if, this camera is recording audio and there's no notice that says it's recording audio? Well, there ain't no notice there anymore. I don't know if it's recording or not. The cameras are still there. So that is the basis for the arraignment in Stoughton. We're going to see what happens there. So I'm going to leave it with you. I know that Linda Kenny Bodden is en route, so we will pick this up a little bit later in the day today. Don't forget, Dina will pop on. I guess she'll be in Stoughton now as well. So we'll all pack up this road show, head to Stoughton, and then rejoin after that hearing and kind of bring you up to speed on where we are with that, as well as what's going on here in Dedham. So other than that, not much going on. So thanks for joining. I'm Michel Bryant. Hang with us as we kind of plod through the rest of the day, and Linda Kenny Bodden will join, and we'll get into some of these things in more detail. Until then, we're going to check out from Dedham. We'll see you here in
so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of ARCCA. So I think I told council before that I had reviewed, so first we had full hearing from council. I heard from the lawyers, I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts, I've listened to the Sidebar conference and read that transcript, and I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the ARCCA witnesses. They were made at Sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the ARCCA witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, ARCCA witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCCA witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at Sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this Sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Yannetti is not pro hoc vice counsel, and Mr. Yannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So, based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the ARCCA witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed
directly to witnesses, leaving ducks around Canton. All 4 of them were not acted upon. There was another instance of what's called the Canton 9, Your Honor. People that were demonstrating in the middle of Canton. There were 9 people were charged with witness intimidation and other related charges, all dismissed. So the Commonwealth just doesn't get it, Your Honor. We need a seminar on the First Amendment. And here we go again. We have Mr. Kearney in this case, Your Honor, is exactly where he's absolutely entitled to be. There's no stay-away orders in place. There's no restraining orders. There's nothing that prohibits Mr. Kearney from going down that street. He went to Jeff McCarthy's for a meal, and he walked by the complainant Albert's Pizza Place in Canton. He looked inside, he saw a camera inside, and looked at it and looked in there and spoke to no one, to a glass window at 9:30, 10:30 at night, 2 occasions before and after. So he had every right to say what he did. The only involvement that the court needs to be concerned about would be if he uttered threats or fighting words. That's already been roundly established in my 14-page memorandum, Your Honor. I'm not going to belabor it. I know you've read it. I appreciate you having that. And the cases are all there, absolutely spot on point, Your Honor. All these issues have been covered. There's no threats here. There's no fighting words. There's nothing that is criminally actionable that happened whatsoever. Because the Commonwealth doesn't like it, they want to use it as probably their 10th or 11th, what I hope will be their failed excuse to try to go after Mr. Kearney. Not because he's a danger to anyone, not because he's doing anything criminal, but to silence his speech. That's what this is about. And that's why I've been so happy to always be coming to the Stoughton Court on these cases, because the Stoughton Court gets it. The Stoughton Court looks at these cases and says, this is not a crime. Stoughton Court has, with an unblemished record, Your Honor, upheld the First Amendment. And I hope that in this case, which is just as weak, if not weaker, than all the other things they're trying to say are felonious activity, I hope the court will address it appropriately, and I know the court will. So in terms of whether the court ought to, whether the Commonwealth rather, ought to be permitted to bring this forward, there's absolutely no basis. Everything that Mr. Kearney said is not actionable. There's no threat, there's no fighting words. The only reason, Your Honor, that this has been given life, Your Honor, is because of the complainant's illegal wiretapping. He had a camera inside the store that apparently picked up sound. And also, Your Honor, there was a camera in the top right outside on the street that picked up the sound of every person walking by. So there's no warning signs, there's no notice that someone is being intercepted under 272 Section 99, the wiretap statute. He's been committing a felony every time someone's voice gets picked up on the street, and there's no warnings about it whatsoever. So Mr. Kearney doesn't have to, when he's clowning around outside the store where he's absolutely allowed to be. And incidentally, Judge, the last time we were all together in Superior Court, Mr. Kearney agreed under Section 87 to a stay-away order on this situation. So that speaks well of his understanding that he's not going to risk any other problems or issues. So that's on the side, if I may, Your Honor, that this has been agreed to when the government brought the bail request that they told me they were going to be renewing here. We agreed to it. So I want the court to be aware of that as well. But in terms of this speech, Your Honor, the only reason that the complainant heard this speech is because he was illegally wiretapping Mr. Kearney. This never would have come to life. He never intended it to come to life. He didn't know it was going to come to life. And the next thing you know, he's being wiretapped by the complainant, who now wants to use his illegal behavior to try to get Mr. Kearney locked up. The whole thing is a complete absurdity, Your Honor. Mr. Kearney is talking for the benefit of his friends to a window on a almost empty street at 10:30 at night. There's no danger whatsoever. There's no basis to plug that conduct into the many elements of witness intimidation to try to concoct some bizarre alchemy, some felonious charge that would somehow get past the First Amendment for all the reasons that I stated in my motion, Your Honor. So that's what I have for the court. I appreciate you reading my motion, and I'm asking for about the 10th or 11th time that the court dismiss these charges. Thank you.
Thank you, Your Honor. Mr. Albert, as is his son, is a witness in the Karen Reed case. Mr. Kearney has been in the process of conducting a campaign against virtually every Commonwealth witness in the Karen Reed case, using his various media outlets. What I would like to do is briefly read the court some excerpts so I can put them on record from the police report of Lieutenant Tully. Some of it characterizes the video that Your Honor has already viewed, but it's also illuminative of the reaction of the Alberts upon viewing that video. After I do that, Your Honor, I will proceed to address the contentions that have just been raised by Mr. Bradle. Lieutenant Tully indicates that on March 5th, he spoke with Chris Albert, and he mentions that the Reed defense attorneys have alleged a massive conspiracy to frame Reed and have stated in written pleadings in an open court that Colin Albert, who is Chris Albert's son, is responsible for the death of John O'Keefe and that Chris Albert has aided in the conspiracy. Beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on civilian witnesses, members of their family, and their friends. He authors and publishes a blog on the website Turtle Boy Daily News. The website has a series of articles entitled Canton Cover-Up. He goes on to describe arresting Mr. Kearney on charges he was later indicted with. Those indictments are still pending in Norfolk Superior Court. Chris and Colin Albert are named victims in those open cases. Chris Albert forwarded to Lieutenant Tully 2 videos from March 4th of 2025. Subsequent to that, Your Honor, the district attorney's office merged those 2 videos, so the video that you saw shows the 2 of them playing simultaneously. They're 2 different cameras showing the same events. The sound has also been enhanced, but otherwise the videos are in no way changed. As described by Lieutenant Tully, the video depicts Kearney walking down the sidewalk from the direction of C.F. McCarthy's, which is a bar/restaurant located next to D&E Pizza at 614 Washington Street in Canton. The group is seen leaving McCarthy's that joins Kearney. Kearney stops in front of D&E and places his face next to the glass window. Interior camera catches him standing close to the glass, staring at the camera for approximately 25 seconds. Male with the group that exited joins Kearney. Kearney then begins speaking into the interior camera for over 1 minute. Audio is captured by an exterior camera. The sound of the occasional passing motor vehicle obscures the audio. Lieutenant Tully stated that he could discern the following statements made by Mr. Kearney. "Hi, Chris. What have you done?" "Murdered," then goes inaudible. "Misses you. Wishes he was alive today. He would be." "Why did you do that, Chris?" "Chris, why did you tell the jury that you got home?" "Why did you say you went upstairs and then waited 15 minutes?" and Colin came home. Colin didn't make it home until at least 12:45. Chris, it was Colin, Chris. I just want to know. I just want to know why Colin took so long to get to your house. Why, Chris? Please tell me why. Colin did it. You can tell me. You can tell me, Chris. I know you didn't do it. I don't want to scare you. Tell Jill to keep their hands to herself, too. The statements made by Kearney in his conduct of standing outside D&E Pizza is similar to the conduct that was the basis for his prior indictments. Kearney directed his statements into a camera that he knew would at least be seen by Chris Albert, a named victim in the pending witness intimidation case and a witness in Commonwealth versus Reed. When Chris saw the video shortly after the incident, he became upset. He stated he is upset for his son Colin and the possibility that Kearney would continue to come to the restaurant and confront him or his son, which I would add, as he has done in the past. Subsequent to that, and as Mr. Bradel indicated, I brought this conduct to the attention of the Superior Court at a hearing on Mr. Bradel's motion to dismiss about 2 weeks ago. Lieutenant Tully received another video, and I want to add, with respect to the first one, that what brought this Chris Albert's attention was that on March 4th, he received a phone call from his son, Colin, who was working at a pizza restaurant that he owned. Colin learned that Kearney was having dinner at the restaurant next door. He was very unnerved and anxious about Kearney being next door while Colin was working. Chris, who was attending a Canton Select Board meeting, traveled to D&E following the meeting, and they closed the pizza restaurant at 9:30 and went home. He then received an alert on his cell phone from the camera system at D&E Pizza, accessed the video recordings, which Your Honor has viewed. Chris was very upset about Kearney's statements into the video camera, especially given previous incidents where Kearney picketed outside the restaurant during business hours. He's also very concerned Kearney will continue to be outside the restaurant and will confront him, members of his family, or patrons in a similar manner Kearney has done in the past. And I think the second video that Your Honor saw was a later discovered video indicating that Mr. Kearney had been present earlier in the evening. Now, with respect to the motion to dismiss, if I can turn to that in this point. I don't have a quarrel generally with the proposition the First Amendment protects a wide range of free speech, and that the usual remedy for a victim of defamation is on the civil side of things and not on the criminal side. But what the defendant ignores, and I believe Mr. Bradel ignores, is the courts from the U.S. Supreme Court on down have said, where the Commonwealth or the state has a compelling interest, it can craft an appropriate limited criminal sanction regulating speech in a reasonable fashion as to time, place, and manner. Now, there are a number of examples of that in our law, Your Honor. I'm sure Your Honor has probably had occasion to issue 209A orders. The typical feature of those orders is that the 209A recipient is to have no contact, direct or indirect, with the victim. And the cases have uniformly supported that when that contact is made, whether it's a phone call, we might otherwise say is freedom of speech, even if it's an innocuous subject matter, even if the defendant sends the recipient of the 209A order, the protected person in the 209A order, a bouquet of flowers, that is a violation that may be criminally punished. We also know that laws protecting courthouses and prohibiting disruptions outside of courthouses are also constitutional and legal. We also know that judges routinely impose conditions of probation requiring no contact, stay away, not travel in a certain area. Those orders, too, Your Honor, arguably impinge on rights of free association and speech, yet all of those are constitutional and have been upheld. With respect to the victim witness intimidation statute, which is at issue here, the legislature has imposed a very limited restriction on speech. And the limitation comes in the form of two elements. One is the protected class is not the public generally. They are left to their civil remedy. But the protected class are witnesses in a criminal case. The second reasonable limitation, the second restriction, Your Honor, is that to prove witness intimidation, the Commonwealth must prove beyond a reasonable doubt the specific intent of the defendant's conduct was to intimidate the witness. Now, it seems to me, Your Honor, that one of two things has to be true. Either 209A orders, probation conditions, and laws against disrupting court proceedings are unconstitutional under the First Amendment, possibly other amendments as well, as is the witness intimidation statute. Or the witness intimidation statute constitutes a reasonable limitation by the legislature in service of a compelling state interest, which is the integrity of the criminal justice system. Mr. Kearney has effectively conducted a campaign against virtually every Commonwealth witness in this case. It has been unrelenting. I don't know if I am to go back to those witnesses, those victims, and say, well, you have a civil remedy, go over to civil court, file a lawsuit, hire an attorney if you can find one, retain him for $1,000 or $20,000 or $50,000, or maybe you can get a contingency fee. And then after depositions and motions and interrogatories and so forth, 3 or 4 years from now, you might recover a nice civil judgment. But in the meantime, every day you are going to be hammered and intimidated, and there is nothing the criminal justice system can do about it. Those seem to me, Your Honor, to be the alternatives. And based on that, Your Honor, I would ask you to deny the motion to dismiss.
I have a couple of.
Briefly.
Judge, page 5 of my brief, U.S. v. Alvarez, sets out the entire field of where the government can intrude on the First Amendment. There's no provision for reasonable restrictions on this or that. There's no opportunity for the Commonwealth of Massachusetts to try to criminalize civil tort law somehow.
I don't think that's what Attorney Cosgrove was saying. I think what he was saying is that it's a different class than the general public. And while I agree with your sentiments regarding Alvarez and the general public, what we're talking about is a more restricted class, specifically witnesses in a criminal proceeding or possible witnesses in a criminal proceeding, and in this case, a known witness in a criminal proceeding.
There's one other issue there, though, which is that there's no stay away order. It's not even a stay away order.
And that's
the determining factor.
well, that may be the determining factor at the end of the day with respect to a defense at trial, or perhaps whether or not his conduct was harassing as the statute anticipates. But the standard of proof that I need to apply here is whether or not there's probable cause that he's violated the statute. And the statute that reads that did mislead, intimidate, or harass another person who was a witness or potential witness.
Yes.
And
Can I address that point?
sure.
Thank you. I appreciate you letting me jump in there. Harassment is defined, and harassment is limited by O'Brien v. Borowski, true threats, fighting words. So manifestly, these videos have no threats, no fighting words.
Wait, so take the sound out of it. The video that I watched that you both submitted by agreement begins with him just staring directly in the camera. He's not passing by. He walks to the camera and then he walks back in the direction from whence he came. And he's staring at the camera for a prolonged period of time before another individual comes up and starts speaking to him, and that's when the words happen. And whether or not you have a Fifth Amendment claim for the witness at trial because of wiretapping or not, it's not what's before me. What's before me is whether or not there's probable cause to support the charge. And after considering your motion and the depths of research you've done on the First Amendment and considering the standard of proof that I need to apply here, which is probable cause, I'm going to deny the motion to dismiss.
No, my objection. Thank you very much.
Your objection is certainly noted. Commonwealth, I hear you on your motion and any request for bail.
Thank you, Your Honor. With request to bail on this case, Your Honor.
Does Mr. Kearney be arraigned first?
He was arraigned. Right, you entered pleas of not guilty. He was arraigned. I mean, I would have stricken the arraignment had I allowed the motion to dismiss. That's why I wanted to address it first.
With respect to the question of bail, Your Honor, I'm going to request that the court set bail in the amount of $5,000 cash on the instant case, and I'm going to ask the court to impose a stay-away order from Mr. Albert and any member of his family. And I'm going to ask that that order, I should say a no contact order, direct or indirect. And I'm going to ask as well that the court order that Mr. Kearney remain away from the pizza shop, from the home of any of the Alberts, and from any place of work the Alberts and that he maintain a distance of at least 100 yards from those locations. The order in the Superior Court, I will say, is a little broader. The order entered the other day, and it now extends to all of the witnesses in this case, but since only the Alberts are implicated in the case before Your Honor, I think it's proper to limit the order here to them.
In the motion to revoke?
Yes. With respect to the motion to revoke, Your Honor, I think it's important to consider that this is the same conduct, or another species of the same conduct, for which indictments are pending against the defendant in the Superior Court. There are indictments for intimidation of a witness with respect to Brian Albert, with respect to Christopher Albert, and with respect to Colin Albert. These indictments represent a series of conduct by Mr. Kearney, including showing up at selectmen's meetings where Chris Albert is a selectman. In one meeting, Chris Albert testified before the grand jury that at that meeting, Mr. Kearney came within 2 feet of his ear, holding negative signs about him, stuck his middle finger in his face, captured on camera for his viewers. And as he left the building, he and a mob of about 15 or 20 people pursued him to his car, screaming at him, calling him and his son a murderer. When Chris reached his car, Kearney and his followers surrounded it and prevented him from leaving until the police were able to back up the crowd. He's encouraged people to harass Mr. Albert at his business. He's run videos attacking members of the Albert family, including Mr. Albert's wife. I'll read you some of the titles of those, Your Honor, that were played for the grand jury. Episode 590, Call to Julie Albert. Julie Albert, I might add, has nothing to do with the Reed case, but in Mr. Kearney's view, she's a fair target because she's related to somebody who is. Therefore, to attack her is another way of putting pressure on and intimidating a witness. Episode 598, Life as Normal is Over. Time to hit the gas. No right for Chris Albert to live peacefully. Albert should be afraid. Kearney outside D&E Pizza. And those, Your Honor, were examples of some of Mr. Kearney's shows prior to the indictment. Indictment has not fazed him, Your Honor. He's continued to harass the Alberts and the other witnesses. When you look at the videos in this case, if you looked at them in isolation, if I looked at them in isolation as a prosecutor, I might think, oh, well, there's maybe a few sheets to the wind after his visit next door. He's clowning around. It's fairly innocuous, repulsive, but innocuous. But understandably, the Alberts and the Commonwealth look at them in the context of the prior conduct. This conduct has continued since his indictment, not only with respect to the Alberts, but as to the other witnesses. If Your Honor has viewed the exhibit submitted by Mr. Bradel, I had some discussion with him about what I would be asking for today. And I didn't indicate, quite candidly, that I was going to move to revoke Mr. Kearney's bail. That was not my original intention. But I did say subject to, I don't recall the exact language, but Your Honor has it in front of him, subject to what may go on between now and then. Shortly thereafter, I discovered that Mr. Kearney had gone on one of his YouTube presentations and encouraged every resident of the town of Canton to file illegal wiretapping complaints against Mr. Albert. Now, I'd be the last person to say complaints that citizens should not contact police departments if they think there's been a violation of the law. But one of Mr. Kearney's attorneys, Mr. Betterow, had already sent a letter, which I suggest was retaliatory in intent, to the Canton Police Department, claiming that Mr. Kearney was illegally wiretapped. Well, the Canton Police can do with that whatever the Canton Police are going to do with that. I think it would be improper for me as a person charged with prosecuting, as a special prosecutor charged with Mr. Kearney, to even express an opinion to the Canton Police Department. I have my own opinion of the merits of the complaint filed by Mr. Betterow. But that having been filed, Your Honor, what possible purpose does it serve for Mr. Kearney to encourage every citizen of the town of Canton to go and file complaints? And I suggest it serves no purpose but to harass Mr. Albert. I would also suggest that it's difficult to look at that video and think anything but that Mr. Kearney clearly saw the video camera, which was visible in the window, and wanted that video recording to be seen and, if possible, heard by Mr. Albert. I think one of the things that may be concluded by the Canton Police, and I don't want to get too far out in front of my skis, is that the illegal wiretapping statute requires that there be secretive video. And when a video camera is clearly visible in front of a store, I would suggest that's not secretive and therefore it's not illegal wiretapping. But if it is, I think when the Canton Police act against Mr. Albert, they can then do a survey of the whole town and possibly bring charges against everyone who has one of those doorbell videos. That said, Your Honor, it was still not my intention to move to revoke Mr. Kearney's bail. But then I became aware just a day or two ago, and I only became aware of this yesterday afternoon, Your Honor. Mr. Kearney, on his show, engaged in about a 10 or 15 minute vile attack on Elizabeth Proctor, describing graphically her giving oral sex to her husband and other such comments. Elizabeth Proctor has nothing to do with the Karen Reed case, except that she is the wife of a police officer involved in the investigation and a witness in the case, and therefore fair game for Mr. Kearney. And I mention this in particular, Your Honor, because one of the things that I understand the Commonwealth needs to show is that no order entered by the court is likely to be effective in eliminating the threat to the public, or in this case, the threat to witnesses in the Karen Reed case and in the Kearney case, and I would suggest a threat to the fair and objective administration of justice. I think that Mr. Kearney, by his conduct, has amply proved the court he is going to keep going with his intimidating conduct as long as he is free. And therefore, I ask the court to revoke his bail.
Attorney Braden.
Your Honor. Your Honor, Commonwealth uses the word retaliatory. This entire bait and switch the Commonwealth has perpetrated on me, Mr. Kearney, is the only thing that's retaliatory here. On Friday, counsel emailed me with respect to the bail issue here today. I said to him that I had, at the time, 2 other cases today. I actually have 3 other cases today. But I don't have time on that date, meaning today, to do what we've been doing here for however long. That if we're going to have a quick bail hearing where the issue is how much money and stay away orders that we've already agreed to in front of Judge Doolin in Superior Court, I could have, that's what I expected today. And I've never, in 32 years of practicing law, had a prosecutor or seen another prosecutor when I was a prosecutor say to me, yeah, come on in, we'll get this done quick, everything's going to be fine, and then come into court 5 minutes before coming before Your Honor and say, no, we're going to revoke his bail. Oh, really? Why? Because he said something nasty about somebody. And here's the kicker, Your Honor. In a private show that people have to pay to hear, not in public, to a private audience that somehow got leaked out to whomever. And that show was Thursday night before the Commonwealth committed to a normal bail hearing where there was a very minimal issue at stake. And now the Commonwealth wants to come in here on 5 minutes notice to me and change it up because of this pretextual excuse about something he said that is non-criminal, non-actionable, that he doesn't like in a private setting. That's what's retaliatory, Your Honor.
Well, perhaps I can short circuit all of this.
Please do. Thank you.
Wasn't this addressed in front of the Superior Court? This conduct was addressed?
It was, Your Honor.
So I think under my reading of the bail statute, Mass General Laws, Chapter 276, Section 58B, that the motion to revoke has to be brought at the first appearance in court. It doesn't say which court, his first appearance in court. If he got arrested in Chelsea, this hearing would be happening in Chelsea at the moment of his arrest. And so the idea that this was addressed in front of the court who's hearing the case on which the Commonwealth seeks to revoke, and there were conditions placed as opposed to bail being revoked at that point in time, I think was the first appearance. And I'm procedurally denying the motion to revoke bail because I don't think it's properly before this court.
Thank you, Your Honor. In that case, we would agree under Section 87, Your Honor, to the stay-away orders requested.
What about the cash bail request?
And Judge, in terms of a cash bail, Mr. Kearney's got no record. He's been to every court appearance. We talk, 10 times a week. He has 2 kids, lives in Holden. He's a former school teacher who has shows that he does every single night. I don't know of anybody who has more roots in here that's not going to cause any sort of a flight risk. So I would ask that you forego a cash bail, Your Honor. And he's absolutely willing to just make it a Section 87 agreed on bail condition relative to stay-away orders. And we ask that you allow that, allow him to appear on his personal recognizance.
So after hearing on bail, I'm going to release the defendant on personal recognizance with the following conditions. Stay away, no contact, no abuse of the Alberts, remain 100 yards away from the pizza shop and any other workplace, stay 100 yards away from their residences. That's with the consent of the defendant.
Correct, Your Honor. May 15th, Your Honor.
That's fine. Oh, wait, was that one of the dates that was not a good date? Okay. May 15th is fine.
So you're going to be released with conditions for your parents back here May 15th for a pretrial hearing. Conditions are that you have no contact directly or indirectly with any of the Alberts and family members, that you remain 100 yards away from the pizza shop and any place of business in the home of the Alberts. Failing to comply with those conditions or picking up any new charges during the pendency of this case, you could be held up to 90 days without bail. That's your bail warning. You'll need to check in with probation. Before you leave the courthouse today, you'll need to sign those conditions of release. Commonwealth's motion to revoke your bail has been denied. The motion to dismiss has been denied. You're all set, sir.
Attorney Bradel, just to be perfectly clear for the record, the defendant consents to these conditions I've checked off under 87 that these are, okay.
Thank you.
All right, thank you.
Thank you.
No, that's all we have.
Court, all right.
Yeah, no, yeah.
article.
This is from the article. Such a great article if you haven't read it. And this, I never, who's ever talked about this except for read it in the article. Your mom had died over the weekend as a jury was deliberating, and sorry to hear that. We all, no matter what is expected when your mother dies, it's not a pleasant thing. And then your dad wakes up in the morning of the weekend at your parents' house and finds at 8:30 that morning, one of Kearney's brothers had stepped out of the house and found a large turtle, because you're called Dr. Turtle Boy, hanging by its neck on a rope from the porch railing. It was dead. The turtle, what appeared to be a gunshot wound, had what appeared to be a gunshot wound in the back of the shell, according to the police report, and an exit wound near its belly. That is, effing intimidation, my friends. That's witness intimidation. That's journalist intimidation. That's intimidation.
And I'm sure they're all over that, Aidan, right? They're all over that.
I mean, the Worcester police, in fairness, did a pretty thorough job. They went up and down. They knocked on every door in the neighborhood, asked for ring camera video, all the things that didn't happen in the investigation of John O'Keefe's death. This turtle got more justice than John O'Keefe did. But unfortunately, the comment the detective made to me was, I've never seen a neighborhood with less ring camera videos than your parents' street. Like it was like devoid of them. And I had a suspect. I had a guy that I thought was crazy enough to do it. They looked into him. They supposedly subpoenaed his Lyft. He doesn't have a car or a license, so he takes Lyfts and Ubers everywhere. And so I think that they got those records, and I don't know what they found. He was never arrested, so I'm convinced to this day is this guy. I don't know if he could just be a crazy. This guy who did it is not doing it because he's a McAlbert. He's just a crazy person. So that could, but either way, I'm still a witness. You know what I mean? It's like
right. And either way, this is what the statute is for. Something like this.
Mm-hmm.
It's not for bullshit.
Yes, it's not for bullshit. Yeah. It's for perhaps when Chris Albert tells me on video on June 23rd outside of CF McCarthy's that he's going to smash my head up and down the sidewalk. That's what he told me on video. Then I was assaulted by one of his employees, Jim Ferris, and another one of his employees by his sister-in-law, Jill Daniels. And I spoke with the special prosecutor about this 2 days ago, or it might have been yesterday. And I was, they're offering them pretrial probation. That's what they're offering them, and they're going to accept that. So not even a quaff they're going to get for this. And I said, why? Why are they getting off so easy for this? And well, they gave us a lot of stuff in discovery, some, videos of you and stuff like that. It's like, so let me get this straight. So because I'm provocative and controversial, it's okay. You can just assault me. It's okay. You can hit me in the middle of the street. You can assault me. You can take my camera. You can do whatever I want because, I'm not sympathetic. So it's okay to do that. And so there really are, two tiers of justice in this. I was actually, speaking of witness intimidation, on January 6, 2023, I went to a hearing in West Roxbury District Court for a woman named Catherine Peter. We call her Crusty Panties. And I was there because she had been violating a restraining order that my friend Lauren Murray had on her. And I went to go support Lauren. And on my way out of the courthouse, Kay Peter was there with her boyfriend, who she had warned me on videos that she was going to bring, and said, don't come to the courthouse. And on video, I'm taping them on the way out. And Andrew Johnson, her boyfriend, pushes me down a flight of stairs on video, just pushes me, attacks me, and it's all on video. I go right to the Boston police, and they review the tapes, and they file a criminal complaint immediately for assault and battery. Probable cause is found. He's charged. And then his court-appointed defense attorney asked for, and to me, this is not only assault, witness intimidation. And his court-appointed attorney asked for the original video. Okay. The original video that I shot it on my phone. Okay. And the Suffolk County DA's office, for whatever reason, acquiesces and it's like, we'll get it to you. And the problem is that
we need more people like you guys to step up. Where's the media? Where's the journalists that are next?
He's in court.
When they're done, where, the mainstream people, right? we're all here.
They're giving
But,
softball
you
interviews
know,
to Elizabeth Proctor.
When they're done with him and me, who's next?
Right.
Where's that person?
Right.
Well, thank God we got you guys.
You guys, thank God I have you guys. Thank you so much for having me.
Yes, that makes it exciting.
Yeah. I love you guys so much,
Guys
man.
like
Thank you
Matt,
guys so much.
guys like Matt.
All right. We'll see you soon. Tomorrow night.
Thank you.
I'll see you over there. I'll see you over there.
How you doing, dear?
Good, how are you?
Good. How you doing? Everything good? Yeah. Where's your mom? Oh, were you making them the other night?
Yeah.
I can work it. Are they stretching?
Yeah.
Said a prayer for my friend Patty.
Oh, is it Dizzy okay? Oh, good for Patty. So good for
Thank
her.
you so much.
Thank you. Very well. Good day to be in court, huh?
Not bad. I mean, we got half a loaf, not a complete loaf.
Yeah, yeah.
Well, at least we're not worrying about revoking payment and going back to jail.
Thank God, right?
Yes, absolutely.
I mean, yeah. Didn't have to be that close, right? Hope you guys can see everything. If there are any questions you want me to ask Aidan, I need you to put them in the chat. Make it so I can see it. How was that? No. What they, yeah, all that. Hey!
Thank you guys. Love you guys, man. I'm going home.
We love you. You're going home.
That was close. That was nerve-wracking. Thank you guys so much for being there.
How much fun was that?
Not fun at all, man. It's the worst time just to have somebody try to, like I said, we got an email from them on Friday saying bail revocation's off the table. And then we get here today and I find out 5 minutes before going in there, it's actually on the table. He just lied. He's a snake and he's dishonest and he lied. And, luckily the judge, I mean, on the technicality, it seems, decided not to revoke my bail. We had a much larger argument than the one that we made. We were ready to prepare because there's no reason to legally revoke my bail anyway. But, we got up on the technicality. So, but, I'm just so grateful, man, to be going home. You have no idea, like how.
Let's go to the McCarthy.
Ever again.
Is this going to affect the Karen retrial at all?
Oh, no, I don't think this will affect Karen's trial at all. I mean, this is just, other than the fact that they try to sully up her reputation with my charges. That's all. They try to take my charges and say she talks to him, so she's bad too. That's the whole purpose of these charges is to begin with, is to sully Karen Reed's reputation and make it harder for me to, activate and get people. And you guys heard him today. He said that I urged people to report wiretapping to the police. First of all, I didn't urge anyone to do that. Secondly, who cares if I did? You're allowed. If you feel like you're a victim of a crime, you have every right to go to the police.
Absolutely.
Since when did that become harassment? To go to the police and say, my rights are being violated, a crime's been committed against me. And I mean, the audacity to bring that up today is that there was something wrong with that. No, there's something wrong with what they're doing. And
Also, the board meeting where they're trying to say that you told people to stand in front of his car.
That never
You
happened.
can't control grown adults.
Video shows
So
all like
what people do is what people do. You have nothing to do with that.
Yeah, I mean, it's hard when somebody gets up there and just lying about you, lying about the things that you're
Absolutely.
saying,
Absolutely.
lying about the things I said in that video. It's just lying. It's just hard. It's hard to hear it, you know,
Hard to wait your turn.
and hard to know that like he's doing this because he wants you to go to jail for 60 days or whatever. And it's like he doesn't care about the other people that this affects, my kids, you know, my family. There's a lot of people that are affected by incarceration. Yeah, you guys, obviously you guys too, you know, like, but so I'm just so happy, man, to be going home. You have no idea.
Well, your voice stands up for all of our voices too. We should-
And how awesome is Tim Brady?
Is the Commonwealth a paid member?
Apparently, I guess he's subscribed. I mean, the thing about that is he sent that email on Friday saying, if anything happens, I'm not going to revoke bail unless something happens between now and then. Well, that happened before. Like this video was Thursday the night before, and he claims he got it sent to him yesterday. I wonder by who. I don't think Cosgrove subscribes to Turtle Club. I don't think he's technical enough to figure out how to log in. He probably, you know, on his iMachine. And so I mean, somebody sent it all because we all know that there's no shortage of people out there looking to take things I said out of context, send it to Cosgrove because this is all just a game to them. That's all this is. Fun and games to try to, you know, put somebody in jail for something that they obviously didn't, you know, do. So
He's behind a paywall though. How's that work?
All you have in this business is your word. And, you know, we had an explicit conversation about it, and I'm just shocked that he would do something like that. I mean, you don't do that. You don't forget something like that. So I'm really disappointed, shocked, outraged. It's unbelievable. I mean, I am so sick of defending this guy over speech. Right? Give me a break.
Well, you're good, they're evil,
they
and you're
don't
gonna
like.
triumph.
Don't forget, we're the good guys.
Yes,
We're the good
that's
guys.
right.
This is complete BS. It's another one of these circumstances where they just unabashedly come into court and say, we don't like what he's saying, so judge, lock him up. It's so brazen. It's so un-American. It's horrifying. And we need more people like you guys to step up. Where's the media? Where's the journalists that are next?
He's in court.
When they're done, where, you know, the mainstream people, right? You know, we're all here.
they're giving softball
but,
interviews
you know,
to Elizabeth Proctor.
When they're done with him and me, who's next?
Right.
Where's that person?
Right.
Well, thank God we got you guys.
You guys, thank God I have you guys. Thank you so much for having me.
Yes, that makes it.
Yeah. Love you guys so much,
Guys
man.
like
Thank you
Matt,
guys so much. All right. We'll see you soon. Tomorrow night. Back in business.
Thank you.
I'll see you over there.
How you doing, dear?
Good, how are you?
Good. How you doing? Everything good? Yeah. Where's your mom? Oh, were you making them the other night?
Yeah.
Are they stretching?
Yeah.
From this judge in West Roxbury District Court to hand the phone over, the Norfolk County District Attorney's Office just ignored them. It basically told them to pound sand, and the charges were dropped as a result of that because they didn't have my original phone that I filmed this assault on. Like the video itself was not good enough. They needed the phone that it was, filmed on, and, got a charge. So like I know this is how the criminal justice system works in Massachusetts. It's incredibly lenient. We're notorious. It's a liberal state, right? But except with me and with Karen Reed, like with us, it's archaic and old school. Like I feel like I'm back in the Tower of London or something. Like it's like I can't look in the camera without being charged with a felony.
You mentioned, some of these different events in which you were the victim, right? And I want you to explain some video here that I think this was about a year ago. This was out in front of, I think, in the same general area of D&E Pizza. And a woman comes up to you.
Jill Daniels.
Is that the one?
Yeah, that's the incident. That's Jill Daniels.
Let me see if I can get that here. Because she's in your face.
Yeah, she takes my camera. She assaults me.
Let me see. I'm going to zoom
All
in.
right.
How'd you pay your tax bill?
All right, so we're down here at Sea of McCarthy's. So we are filming for our own protection
Here
here.
she comes. She's about to come.
Oh, look who it is. Look who's here. Here she is.
I'm so sick.
That's number 2.
I'm sick of your shit. Okay? Enough is enough. You're a prick.
Can I have my
phone?
Looks like you held onto the phone that time, right?
She held onto the phone.
Oh, she's
holding it. Fuck off.
You're a fucking nerd. You look fatter than me. Boom.
Boom.
Where's your chocolate? Where's your chocolate? And I'm sorry. Didn't you go loopy? Didn't you go crazy?
Bill, can I please
Shut the fuck up.
I'm like, can I have my phone back?
Can I have my phone back?
Mr. Armour.
Go ahead and give him his phone.
Give my phone back, Bill. Don't do that. I need my phone back. Okay. Okay, so that just happened. That just happened. That just happened.
Piece of shit. I have wrinkles. I don't care, but guess what? I have a good heart.
You have a great heart.
Prick. You're going to jail, and I cannot wait. And guess what? You're going to be without a boyfriend because this prick is going to jail.
I mean, I'll be with my boyfriend longer than you will. You're just gonna die.
Okay, don't even worry about it. She's not worried. This is a trap. Just let her talk. 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 Don't even talk back. Don't even talk back. Don't even talk back. Don't even talk back. Who are you yelling at?
Who are you? Like, look at you. How many times you got punched in the nose?
I don't
Your
know.
teeth, you make fun of my teeth. Yours are chicken.
No, it's mostly your skin, but okay.
My skin, I
Yeah.
have wrinkles. I don't care.
I mean-
I stick up my family. How many siblings do you have? Has anyone stuck up for you?
A bunch.
No, they don't like you.
They don't?
like
Okay,
you.
if you say so.
You guys can all tape me. Like, why are you taping me?
I can't imagine why. I can't imagine why anyone would want to tape you. Your behavior is normal. No one's harassing anyone. I'm just trying to eat dinner.
Why are you here?
Because I'm hungry. Because they serve food in here.
Why are you here to cause trouble?
Because I want food. Because when you're hungry, you eat food.
Why don't you just leave everyone alone?
I am. I'm just trying to eat food. Because I got assaulted by Jim Farris. We're walking out. Some people asked me to take pictures, and next thing you know, Jim Farris comes up to me and assaults me. You drove up here. Look at this shit. You're double parking. Because they killed John O'Keefe.
No, they did
Yes,
not.
they did. They obviously killed John O'Keefe.
No, they did not.
I was not there, but Colin was. I did not kill John O'Keefe.
Are you guys coming?
Like,
So
we'll see.
He got assaulted. He got assaulted again, and his phone was.
I mean, that's why Ryan said that he didn't see John O'Keefe was not in the car or outside the car.
Thank you.
Like, that's why he testified that. So,
Here's the cop.
we got that on
There we
video,
go.
right?
Yes, I.
Okay. We got. So,
You tape me all you want. I don't care.
no, we're not going to tape. I'm just going to tell the cops what happened.
I don't
Yeah,
want
keep going. Keep going. Keep going.
Yeah, that's basically it.
Yeah. So, and tell folks who she is. She's, in my opinion, she's kind of a peripheral character.
Well, that's Jill. That's Jill Daniels. She is the sister of Julie Albert, the sister-in-law of Chris Albert, the aunt and godmother of Colin Albert. She is a very outspoken and, as you can see, out of control.
Wow.
McAlbert. She is not a witness in the trial at all, but she is a very loud person on social media. She makes a lot of fake accounts and trolls people all day. And, she was assault. So she was charged with that. A month later, she got charged again with assault and battery in Falmouth at this bar called Shipwrecked, because according to the police report, she was once again recognized from the CF McCarthy's incident because she's famous now. And they're like, people were razzing, like, you're Jill Daniels, you're the crazy lady. just. I think Karen Reed learned a lesson about why you're told not to talk. You know what I mean? Because
Miranda card.
that is what Hank Brennan has. That's all he's got at his arsenal, is taking things that Adam Lally did not do this, and Hank Brennan is. And just micro analyze every single public statement that you have made on or off the record with a reporter. And there are no shortage of that, because she's not afraid to talk, and just try to take something she said in bad faith and try to misinterpret it to make her look like a liar, like a dishonest person. That's all he's got, because he's a defense attorney. That's what they're taught. Like, that's how he does. That's how he's conducted business his whole life, except doing it, the opposite way, because he's usually used to defending scummy people.
So Michael, what Aidan suggests, that tomorrow Justice Serve TV should send Mr. Morrissey a letter asking, or an email asking, how it was that Hank Brennan was the person that was chosen.
Sure.
I mean, I don't think anyone has ever gotten on.
I've not seen that discussion with anybody. I don't know that we'll get a response, but I have no problem reaching out.
Send the press secretary. They got a new press secretary, David Linton. You can ask him. I want to say, let me bring up my email, because I messaged Mr. Linton right when he got the job. And let's see. So I asked him, I go, hi, this is an email I sent on November 4th. I said, my name's Aidan Kearney, and I'm a reporter from the Daily News. As we discussed on the phone, I guess I called him, I'm writing you for comment on this quote from a recent Vanity Fair article on the Karen Reed case. Quote, meanwhile, according to sources, Morrissey's top prosecutors have refused to retry Reed's case. So he has taken the unusual step of retaining outside counsel to spearhead the next trial, Hank Brennan, who defended Whitey Bulger. And then I said, if this is true, then it would be a stunning admission that ADAs, who get paid by the taxpayers to prosecute cases, have refused to do their job. It sounds like insubordination, and I have some questions about that. Number one, what were the stated reasons that all the prosecutors in the DA's office refused to retry the Reed case? Were they ethically opposed to participating, or did they hope to avoid the same public humiliation Adam Lally was subjected to trying such a hopeless case on national television? Number two, will there be any discipline for this act of insubordination? And number three, does the DA's office find it at all problematic that the taxpayers must now pay an additional $75,000, actually make that $250,000, to Hank Brennan to do the job that we pay prosecutors to do? Thank you. And his response was the following. Aidan, in reference to your inquiry about the Vanity Fair article claims citing unnamed sources, the DA's office is not commenting on the article because it concerns a pending case. I can, however, refer you to the DA's announcement on September 18th. As was reported previously, Hank Brennan is being added to the team along with ADA's Caleb Schillinger, Adam Lally, and Laura McLaughlin. There are now 4 attorneys on the team to retry Karen Reed. And then he gives me the statement that he made about Attorney Brennan on September 18th. So basically, he tells me nothing. I'm not going to answer any of your questions. And here is a boilerplate thing that my bosses gave me to give you.
Yeah. So, but the question is, how did this name come
How did
to
they
him?
pick this guy,
How did they
this
pick
star?
this guy? Who recommended this guy?
That's a good
You know,
question.
that's the question. Right.
He's got a lot of ties. He's tied to the Krauskis, who are, Joe Krauske Sr. sits in the jury box by himself at these pretrial hearings. He's like 1,000 years old. Call him Izzy Mandelbaum, and he sits there. He's Jill Daniels' lawyer, actually, and he sits there. And Joe Krauske Jr. goes on national TV and defends the Commonwealth on court TV during the trial. And I think that they are very close with Hank, and that they probably were like, hey, hook it up. Maybe they recommended him to them. We also know that Hank, prior to being hired, he took down his Facebook page, but we had a tip that he might be the guy. And so went on his page, and I screenshotted his whole friends list and who he's friends with. And he's good friends with a woman on there by the name of Carrie Lama, who is best friends with Jennifer McCabe. And so it seems like he's tied to the McAlberts. He's in that circle, and he's just kind of doing the bidding for them. I mean, this is the most protected family in America. I mean, you thought Chelsea Clinton had it good. I mean, this woman, or Hunter Biden, like this guy, the McAlberts, They are the most insulated family. Like the state effectively acts as their own private defense attorneys.
I had quite the in-depth conversation with Mr. Brennan on the courthouse sidewalk. I thought the cops were going to come and wrestle me, but I was showing up at about the same time he did, so I just crossed the street. And this, they got the barriers up, right? So only the crosswalks allow you to get between them. I've got all my gear, and I see him. I go, let's go talk to him. So I introduced myself. I asked him, how's the adventure going? And he just said, nice to meet you. And he toddled off. But the troopers were like checking me out like I was going to bash the guy over the head with.
I hate that. I hate the atmosphere out there with the troopers. And like they yelled at me one time and threatened to arrest me because I attempted to ask the defense questions. Like, you can't ask them that in the zone. You're in the, like, are you it's scary out there. Like this whole thing, what is happening in Norfolk County? This inability to ask questions, that it's witnessing, like what they did it to me. They opened the book to everyone. They're like, oh yeah, we can just threaten everyone with this. If you
we do come from a history of Sacco and Vanzetti in that courtroom. Okay.
And not much has changed.
Not much has changed there. Olivia now says, but it also just shows how disingenuous the Commonwealth is with how they selectively choose things or mischaracterize them, deliberately pretend to mean something they obviously no, they don't, which is what Aidan's been saying. So please go to Aidan's channel, subscribe to his channel. He has a great channel, and Missy's going to put up his channel name again, and also hit the like button here tonight because Aidan's giving us time to talk to all of you on the show, and also about this Carrie debacle. I mean, this is a debacle in terms of what happened with the jury, Aidan. I just don't get it. Why you couldn't bring them back and ask them the questions of what did you find?
You can. You can do that. They choose not to. They don't. I mean, you would think that Auntie Bev, a former defense attorney herself, would be troubled and have trouble sleeping at night knowing that, oh, wow, did a jury actually reach the conclusion and vote unofficially that this woman was acquitted of murder 12-0? Like, that should bother people. Like, that's the kind of thing that should keep you up at night. But it doesn't seem to bother her much at all, because she just doesn't like Karen Reed.
Yeah, and if you're predisposed, even on a subconscious level, like we think she is, then sure, you're not going to go out of your way to correct what was clearly a mistake that if she didn't make, she made far worse by just not asking that one question.
Mm-hmm. Yeah, and it's asked in every single case I've ever been in. I mean, we just heard it asked in the ASAP Rocky, or we heard it instructed in the ASAP Rocky case before the jury went in. By the way, if you come to a decision on any count, but it can't reach a decision on another count, please let me know, and I'll let you come out, and talk about it. Ryan S. says what shows her bias is the last bench trial with Penny McGee, where she found Penny McGee not guilty. She can do the right thing. She can follow the law, but her decisions here show there's something not at play in the background. So that's what's coming out here. Now, this is a real interesting question. Michael, could you read this and see this?
Sure, I could read this.
Yeah.
From To Making It Count, could the home be reviewed for evidence underneath the floor or under renovations, etc.? Seems that could be considered tampering with the crime scene. Boy, there might be some time issues, and now it's there's some custodial issues because the house was sold like a fire sale pretty quickly, right? I feel sorry for the folks that live in there now. But I think
they'll get right on that. Yeah, they'll get right on that. Yeah, they're gonna. I mean, what planet are people? No offense to this person, but like, where are you? Are you new here? Yeah, they're gonna do that. They're gonna be like, yeah, that's what Auntie Bev and the Norfolk County DA's office is gonna do tomorrow. They're gonna be like, hold on. We need to go look under the floorboards, and we need to start holding these people. They're not going to do anything. Like, once you realize that they're just corrupt scumbags who are so used to the status quo, you'll stop asking questions like that.
See, here's what I like, though, about our viewers. They still have hope. They still hope that the right thing will happen and the right thing will be done.
They want it to happen.
I've been around this too long to know.
So let's do this. Let's talk about current events, and then we'll dig deeper. you have a hearing coming up next week, right? On Tuesday, the 18th. Is that correct?
Tentatively scheduled. We're trying to, both of my lawyers have conflicts that day, so we're trying to move it. So
You
we'll
are?
see.
Okay.
Yeah.
Okay. Good. Put me in the loop on that because I was going to come up for that. But it's going to happen, or do you think there's going to be a deal that will prevent it from happening?
I have no idea. I mean, it's up to the prosecution, I would assume. I mean, I think there's a certain gentleman's agreement amongst attorneys that if somebody has a conflict that day, if it's no good for them, they'll reschedule it, right? I mean, I've seen it a million times before. Obviously, it's not too much of a pressing issue if they can afford to wait 2 weeks to arraign me. It's obviously not, I'm not a danger. It doesn't need to be dealt with.
I don't know. I feel intimidated already.
And may I say this, and we're going to discuss it later. How about Mr. Prosecutor or Madam Prosecutor or whoever the prosecutor is who's going to be in charge or play with or deal with dropping the charge? Let's start with that, and we'll discuss why later on. But not that I make my opinions known to anybody, Aidan. If you know me, you know that I'm not shy.
Yeah. Well, I know you're an attorney, so attorneys generally aren't shy in that regard. But yeah, I mean, this of all the charges I've gotten, this is probably the most absurd, and that's saying something because they're all various levels of absurd. But looking into a camera and briefly talking into a camera that you have no idea is actively recording you, and then calling that witness intimidation is perhaps the most absurd overuse of the law I've ever seen.
Yeah, well, as everyone here who watches us knows, I've tried cases. I sit next to people accused of shooting people in the head. Phil Spector, Aaron Hernandez. Those are alleged crimes. At least you can charge whether a person's guilty or not. This one, I think the only crime that was committed may have been by somebody else. But again, I'm getting ahead of myself because it's such an issue for me in terms of this whole wiretap issue that I'm going to let Michael take back.
Oh, yeah. I mean, I love we went over the Mark Betterow letter last night, and I've talked pretty extensively with Mark both at the scene, and I chatted with him a little bit prior to the latest Pro Hac Vice denied, which we could talk about in a second because that's another ridiculous decision. But I love the creativity of this wiretap letter. Do you expect, for those who don't know, Mark Betterow, Aidan's attorney, writes a letter to Chief Rafferty and says, hey, you might want to check into this because they're violating whatever the code section might be by having this camera outside D&E Pizza that collects sound. And Massachusetts is a two-party state, meaning before you can record somebody, you need just my permission as the recording person and your permission as the recordee, or it's wiretap. And so I've never seen it applied in kind of a public setting like this, but the law is the law, right? In fact, this is a picture that we got. We took it from one of the videos I did, and Aidan, this will show you that I'm more concerned about the craft than my vanity, because this picture is not exactly flattering, but it does show what we think is the location of that camera. And I will point out, before you cross-examine me, it is inverted. So you can tell
it is. It's true.
Inverted. So is this, I don't know.
No, that's not it.
That's not the camera. Is it more in the corner over here?
No, it's in the, well, it would be if it wasn't inverted.
So it's actually off screen over here.
Above the door. So
okay.
We like the camera I was looking at was more towards C.F. McCarthy's. Like I came right out of C.F. McCarthy's. I see a blinking light right above that Canton Police, we respect Canton Police sign. Okay. And I'm like, you look at the blinking light, and I'm like, if you watch the video, I'm like transfixed by this light. I'm like looking at it, like just staring at it for like 25 seconds. And then they all come out and they're cracking up. They're like, what? Like we have been drinking. And they, it's like Aidan is doing a bit. He's staring into a camera, like what appears to be a camera. Now, I had no idea that I was being recorded until the next day when I found out I was being charged. I'm like, wait a minute.
Well, that's the great thing. If it's illegal to record under the wiretap statute, so you wouldn't expect those cameras to be recording.
Right.
right? All right.
Especially with the
How
guy
could
with the
you-
sign that says "We respect police" in the window.
How could-
This is
how
a
could
law
you
and
have
order
it-
guy.
Right. How could you have the intent to intimidate if you didn't believe anybody was looking at you?
Well, they're going to say, well, then why did you address Chris directly? It's like if you watch the tape again, I'm there, I'm silent for 25 seconds, and then Will comes up from behind me, and he's like, "Let's do a little bit here." He like puts his things in me and does the T-Rex arms, and he's like, and we just start putting on a little show. Right. For no one in particular, just for the group that we're with, they're laughing. Everybody's laughing. You know what I mean? I'm not talking to say that I'm addressing Chris Albert is just such a reach. You wish, like they wish I was addressing Chris Albert. Like they're just looking for any opportunity to revoke my bail. Brian Tully asked for them to arrest me. He wanted an arrest warrant out for this. He wanted to have me arrested on the courthouse steps when I went into my motion to dismiss because he knew all the cameras would be there. So, I mean, this is lawfare. This is people that are just weaponizing the justice system. They don't care how they look. They know it sounds ridiculous. They know how pathetic it is to have all these grown men crying about witness intimidation because of little old me. And they just don't care because the ends justify the means. They're just like, well, the goal is to put this guy in jail, teach him a lesson. And if we have to kind of degrade ourselves a little bit by pretending to be little girly men who are afraid of our own shadow, then so be it.
Anyone doesn't know it's Will. We had Will on the other night.
Yes, and you see he's mentioned he's pleading the fifth. So, and I've got some of the. I want to show a couple of those little clips just so people who haven't seen it, especially the one where you're audio recorded, they can kind of get a sense of what's going on here. Before I do that, I think it's ironic, Aidan, that all of this effort to go after you is really highlighting the incompetence and the motive of the cops in the Karen Reed case. It seems to me it just backfires on them.
What do you mean?
Well, I mean, why would they go after you? Why would they use all this to go after you?
You know the answer to that.
But what it's doing is telling people how bad the cops are as it relates to the Karen Reed case.
Yeah, in the investigation, right? They wrote 6 pages on your arrest for a allegedly intimidation here on a ridiculous public street with a pizza parlor, and yet they don't go in, as we said the other night. They have a dead body at 134 Fairview, and no one bothers to go into get an arrest, a search warrant to go into the house to check. Hello.
Well, I mean, it's entirely consistent with who they are. I mean, this is what they've done the whole time. They had a 36-page report over rubber duckies. Do you guys know about that one?
Oh yeah,
like rubber duckies. Like they did. That was a 6-month operation that they did. At least with me, it was done in 49 minutes. The investigation was over. With Rich Schiffer, like they did a sting. They did freaking subpoenas. They did garbage. They dumpster dove for information on rubber duckies and stickers and whatnot. So with me, it's the least surprising thing ever. I've realized this since the day that they arrested me, October 11th, 2023, and charged me with these. That's when I realized that they didn't care. That's when they're like, oh, they just don't care at all, because they have to know how bad this looks. Like they have to know that like the guy who is criticizing you guys just arrested me because you're mad that I'm criticizing you in particular. And let me just tell you, there's some stuff that's I can't talk about because of protective orders that you don't know yet, and you haven't seen the half of it when it comes to motive for these people.
Well, I just talked to Aidan just a moment ago, and he was in a pretty good mood, considering what was hanging over his head there. Hey, Michael Bryant here. A little change of scenery today. Stoughton District Court here, which apparently is a little bit more reasonable than the Dedham Court. Nonetheless, I just came out of the hearing in which Aidan Kearney was very relieved not to be going inside, further into the bowels of justice here for bail revocation, which was requested by the prosecution. Let me tell you what happened here, because, and by the way, I just posted the post-hearing, little presser that Aidan had on the courthouse steps here. So check that out when you get a chance. Anyway, so I talked to Aidan this morning, which you may or may not have seen. And during that conversation, he was really kind of breathing a sigh of relief because he had heard as of Friday that the prosecution was not going to press for bail revocation. This was going to be just a routine arraignment on this latest, what I'll call the D&E pizza charge. That's where he was goofing around with Will the Glarer in front of the cameras that are outside D&E Pizza, right next to McCarthy's. And that was interpreted by the cops and by Chris Albert, the owner of the pizza shop, as witness intimidation. And so that's what Aidan was told, and his attorney, Mr. Bradel, was told. This is just going to be a quick in and out, ready to go. But you could tell, and if you watch the interview from this morning with Aidan, until it's done, it's not done. And that sort of, realistic reservation served to be perfectly legitimate, because they get here and I'm watching, I'm inside the hallway. They've already passed us through the intense security. And I first thought there were like 35, but there were about 50 people that were queued up to fill the courtroom in support of Turtle Boy. And so while we're just waiting, it was at least a half an hour. We're just hanging out in the hallway, chatting with folks. And more than anything, I'm watching this back and forth between Mr. Bradel, Aidan's attorney, and Aidan, who is with his girlfriend in the lobby. Spoke to her earlier today, too. Lovely, lovely woman. She's a CPA, mostly for corporate stuff, so I couldn't get any free tax advice from her. But anyway, they're going back and forth from the office, which is clearly the DA's office. They have an office in the courthouse. So something's happening. You can just tell something's up. They're spending more time prepping to go in and do this than they really should have been to do an arraignment. Arraignment is just as a little primer from Justice Serve TV classroom. That's where formal charges are brought, no matter what the crime, whether it's jaywalking or murder. An arraignment is where formal charges are officially brought and where the defendant will enter a plea. So that's what was supposed to happen. But this back and forth led me to believe, I don't know, something wacky's going on here. That's when it turns out that Cosgrove, the DA, remember, this guy is a special DA. I guess they have no DAs in the county. They have to bring in special prosecutors for everything. So this is when the hearing unfolds and we learn that, so there was a little shenanigans underway. All of a sudden, the prosecution decides, I wasn't really going to go for bail revocation based on this incident and then he starts, rattling off things that have changed Attorney Cosgrove's mind about whether to seek bail revocation. And they were, among other things, the letter. Remember the letter that Mark Betterow wrote to the Chief Rafferty of the Canton Police to say, hey, this camera outside the pizza joint is picking up audio. Therefore, it violates wiretap statutes because in Massachusetts, as we've talked about before, it's a two-party state. Means if I'm going to record something, I need both my permission and the person I'm recording permission. So if you're walking up and down the street there, as I was yesterday, and you're picked up on this camera and you haven't given approval or there's no notice saying it might happen, that arguably is a violation of wiretap law. So Mark Betterow sends this pretty well-worded a letter to the chief of police. That triggers, apparently, Aidan putting out a notice to his buddies, his fans, that if you've been in that area, you might have been illegally wiretapped and you might want to file a complaint, right? So the DA, Cosgrove, decided that was one of the aggravating issues. And the other one had to do with, and I made my notes here because I couldn't believe there was a second one. Hold on, stand by here. The letter, yes, that was the one thing, and that equated, in his opinion, to further harassment. All right, but he still said that wasn't enough. That wasn't going to push me over the edge to seek bail revocation. But yesterday afternoon, that's on the hallowed holiday here in this part of the world, St. Patrick's Day. There was a broadcast by Aidan in which he attacked Elizabeth Proctor. Now, you'll remember, of course, we know the Proctor factor. We know John Proctor. But as of the day of his, I believe it was third disciplinary hearing, I'm going to call it, for Mr. Proctor, his wife put out a letter from the family, but the wife was kind of front and center, Elizabeth, really just boo-hooing how poorly her husband had been treated and how unfair it has been. So in response to that, Aidan on his show basically kind of goes off on her in his way. I won't get into details. If you heard the audio, which we ran here from the hearing, we ran it here on Justice Serve TV, you'll know that according to the prosecution, there's some discussion about Elizabeth Proctor giving her husband oral sex, blah, blah, blah. Anyway, that was it. That was the tipping point, according to the prosecution today. That was the point at which Cosgrove decided, no matter what I told you on Friday, counsel for the defense, we're going to go for bail revocation today because it's clear your guy, Aidan Kearney, is not going to shut the F up. He didn't say that, but that's the spirit, right? That there's no way to shut this guy up unless we lock him up. So that sounded kind of ominous, right? And you never know what a judge is going to do. You'll never know. And by the way, Judge Walsh, who's the normal judge here, is on vacation. So this was a fill-in judge. So the uncertainties and the unknown are multiplied, right? Because who knows? It's a new guy. Maybe he's trying to make a name for himself. Maybe he doesn't care because he ain't going to be here to pick up, the fallout from this case or cases as they proceed. Remember, some of these witness intimidation cases are in the Superior Court in Dedham. And that's key. It's going to be very key to the ultimate outcome of this attempt to get bail revoked. So Cosgrove makes his plea and he mentions these triggering events, and that's why I finally decided there should be a motion to revoke the bail. Attorney Bradel gets up and he's basically preparing to rebut those arguments, and he barely gets started when the judge steps in and says, well, wait a minute, let me just kind of cut you off there. Sometimes that's good when a judge does that. Sometimes it's not so good. And sometimes you just don't know. And in this case, I don't know, to me, there was a hint that this was going to be good news for the defense, and ultimately it was. The good news was, according to the judge, any attempt to revoke bail based on an incident, in this case, remember, bail was in place for the 16 pre-existing witness intimidation related charges. This would be number 17. This would be a new one. This would be coming up post arraignment of those other charges. So this is key because the judge said, well, if you want to try to revoke bail based on an incident like that, you need to bring it up at the first appearance. Well, when was the first appearance for this incident? It was last week when it was brought up by the court unofficially on day, I think the 4th, and then remember the 5th, they actually had a hearing at noon on that day. They brought everybody back in because the defense counsel said, well, you can't just ambush us with this. Come on, it's got to be properly presented, which it was the next day. It was at that hearing where any attempt to revoke bail should have been brought up. And because it was not, it was waived by the prosecution. Now, I'm not so sure Cosgrove knew that, cared. He was motionless during the whole process after he'd given his spiel. But there was a kind of a collective sigh in the room. Like I said, 50 plus supporters in there, plus of course Aidan. And I could tell, Aidan's a ballsy guy. Let's admit that. But I could tell as I'm sitting there watching him. I'm like 10 feet away as this is unfolding, and you could tell, the wheels are spinning in his head because, as he told me this morning, you never know until it's done. You never know. And he was stone-faced, and let's just say for the Turtle Boy that everybody has come to know and either love or hate, it was reflective. He and when he was out here on the courthouse steps and finished his speech, I said, congratulations. I said, kind of a tough, hairy moment there, right? He was like, you have no idea, because he really didn't. He had no idea what was going to happen since this had been dropped like a bomb right out of the blue. Of course, now in retrospect, and Aidan mentions this on the courthouse steps again, I've posted that, this is like business as usual for law enforcement and the prosecution and the Commonwealth in this part of the world. And Attorney Bradel makes it clear, this guy's been practicing 32 years. He's never had a prosecutor basically, if not lie to his face, certainly sandbag him like that, to say on Friday, yep, we're good, ready to go. all of the things other than that one reference to Proctor and Mrs. Proctor, all the other stuff had already happened. So if he's claiming 2 aggravating events over the weekend, or since he represented on Friday, it was going to be a straightforward arraignment, one of them had already happened. So he's lying about that. The only thing that happened since was the reference to Elizabeth Proctor following the presentation of the family letter supporting former officer John Proctor. So, like I said, Bradel shocked and, made him, he's practices here. He said, I can't believe anything these people tell me. So that was all that happened. That was it at this hearing in Stoughton. By the way, I have Dina on speed dial. She, like a lot of these supporters, have been out and about since early this morning. And so she said, I got to grab some food. I said, well, I don't want to go there. I'd rather have you come back here if you're willing, because look at the lovely setting. And so she is. She'll send me a text. Maybe she already has. I should have asked her to get me a sandwich because I too have not eaten. So we'll see. And obviously, we want to get her take on what's happening. She's a very vocal spokesperson for the Free Karen Read movement. I've talked to a number of them here over the times that I've been here. I've gotten some names and contact info. So as this case unfolds, and there is a trial coming up in 2 weeks, we ain't seen nothing yet. We'll have these folks on, here and there to share their opinions on, obviously their overarching position pretty clear, but still good to get some input on specific witnesses, specific pieces of evidence, and those kinds of things. So anyway, she's going to be coming on here as soon as we can get her back from food, and maybe she'll bring me a doggy bag. I don't know. Let's see what else went on that we didn't get to from earlier today. As you may or may not know, tons of motions to be heard. The motions in limine were to be heard, as many as could be today, and then some tomorrow. But the judge, and I think because of this issue, Judge Bev, maybe I'm giving her too much credit. Maybe she had a hair appointment. I don't know. But because I think this was going on this afternoon, she called it basically at halftime, barely getting started today. They got through 5 motions. So they're going to be back at it full speed tomorrow, which cost us a little, got a programming flexibility, I think we would call it in the business. And that's what we're doing here. So we're going to chat with Dina when she comes along. My partner in true crime is en route to her location. And so we will reconvene at about 5 o'clock tonight. I'll be here. Linda will be back in Manhattan, and we'll just kind of rehash all that's happened. We'll talk about the motions that didn't get heard that were just filed yesterday, and tons of others that we've been talking about really for the last week, since I guess the number's now well in excess of 40. And again, as you probably could tell from today, some are just, okay, no objection. We'll work that out amongst ourselves. And then, you just go forward. I see from Jason, you're saying the court said it's going to be Thursday, not tomorrow. I will defer to anybody else who got that info, because I was in front of this little thing as they were doing the sidebar scheduling. So let's confirm that. I'm not staying over to do tomorrow, even if it is tomorrow. So, and that's all I care about is my schedule. I mean, come on. So we'll be reporting on this stuff whenever it happens, tomorrow or Thursday. From the home front. I'm hearing Missy is also saying Thursday. Okay, like I said, I was busy. I wasn't, and they didn't bring me into the sidebar, and nobody yelled it out. I should have asked Dina. Dina has been my inside info for this. All she did was tell me we're done for the day, which surprisingly we were. So let me see if there are anybody got any questions that I can look at. Well, it is so hard to see out here. You'd be amazed how brilliantly bright it is. At least that's something that's bright. Boom. Let's see. How was that phone audio, by the way? The Zoom, was that did that work out all right? I'm glad we could get that info and get that done for you, because it's better than nothing. It ain't like being in there, but yeah, it is. It is better than nothing. And let's see. Oh, I talked to a couple of other folks that we're gonna incorporate into our shows over the next. One woman is, and I know you guys will be familiar with their channel. I think it's called. I know I'm going to get this wrong, but I think it's on their Facebook group. Do you know there's Facebook still exists? Did you know that? Facebook group is called. I think it's Law Girls not attorneys. Does that sound familiar? Anyway, Amanda, and she has this amazing 15-year-old daughter that I think I took a picture of, and we posted a picture that she took last time I was here. And it was a picture of a dog, and it said, I bit her, I bit him, I bit him, I bit him, and then a picture of Chloe the dog. See what she did there with the I. Anyway, so this girl is totally learning her civics on the fly, and her mom, who's a paralegal, Amanda, will be joining us at some point during the process as we continue to kind of dig into this case. We also have Scott McGinnis, I think, is going to join us as well at some point. So we're gathering up a number of folks to be, if not our 13th juror, maybe our own little jury panel. Let's talk about, well, we got a minute here. Let's talk about the motions that were filed just yesterday. Some people thought it was a holiday, but no. So let's talk first about, and I know Linda and I will talk about these. We'll get her input as she joins us a little bit later on this evening. Again, we'll come back live at 5 o'clock tonight. We just want to wrap this up here, talk to Dina from the scene, and then we'll leave you to rest up and relax, and we'll come back at 5 o'clock to tear into this a little bit more. This was a Commonwealth motion, the new one, to limit the testimony of Michael Easter. Now, who's Michael Easter? He's a retired FBI dude. He is supposed to be bringing opinions, again, for the defense, about the inadequacies of the investigation. How much time do we have? How much time is this guy going to need? That's his deal. He's actually, and the Commonwealth was not objecting to this. He's a cell guy. He's a cell phone guy, but he has no training, no experience in law enforcement or law enforcement investigative practices. So why are you having him as an expert that he's not really qualified to give opinions about? So that's one thing that he's going to be talking about, or at least he's going to try to be talking about if the court does not rule in the Commonwealth's favor and bounce him. As you've seen with a lot of these motions, quite often the court's ultimate ruling is, hey, these things go to the weight of the evidence, not the admissibility. And to be honest, to me, that should be the default position. That should be what the court is looking to do. You don't want to take, if it's relevant, if it's otherwise admissible, you don't want to take from the jury an opportunity to better understand some of the specific incidents in a case that are beyond lay experience. And that's the difference between an expert testimony and lay witness testimony. One of the things we've talked about that I think could cross both is the ground is hard as a rock. I don't know if I need an expert for that. That sounds like lay testimony to me. But in most cases, you're talking about cause of death, manner of death. Those things are for experts. And in this case, an expert regarding the investigative skills or lack thereof of the Canton Police Department. That is something the Commonwealth would like to keep out. They talk about how that testimony could somehow dovetail with the third-party culprit argument. Remember, the defense is effectively saying, whether you call it a conspiracy or just the prosecution's failure to prove their case, something happened in that house. Maybe it didn't. As I've said many times, at the end of the prosecution case, if I still say, I don't know what the hell happened, they lose. Okay, that's the bottom line. So they're concerned that this witness will help that third-party culprit analysis, and they also suggest this is something. It's a local statewide case called Bowden, and that's a case that basically says the cops were ineffective. So the Commonwealth is concerned that any attack on the police investigation as inadequate is going to somehow bolster their third-party culprit position. I don't know. Maybe they're just scared. I don't know. Another one came out from the Commonwealth. This was their opposition to the defense motion for lack of bias. Now, remember, this takes us into the deep, dark recesses of ARCCA, okay? Because we know how traumatized Judge Bev has been about the defense interaction or lack of interaction or truthfulness of interaction or a lack of candor of interaction between the defense team and ARCCA experts. And I'll remind those who missed it this morning, it was just, I thought she was going to stroke out. She was so upset and wasn't sure what to do with the defense because all of her studies told her that there had been flagrant and intentional misrepresentation about the defense relationship with the ARCCA experts. So this relates to that, because the defense wants to make it clear that there is no connection, that they were an independent third party that ultimately was paid for by the defense, but they were not retained. They didn't pay for opinions, and that's what the Commonwealth would like to argue. So to allow them to argue that, they have to oppose this motion by the defense that says we want to be able to present, Your Honor, that there was no bias between the ARCCA experts and the defense case. Commonwealth says, no, we want to be able to throw it out there. And here's one of the things they've referenced. I thought this was odd. They've referenced a picture of Dr. Rentschler. Now, you remember Dr. Rentschler? He's the expert that's not an MD and therefore had his testimony limited because he's not an MD, Dr. Crosby. And there's this picture of Dr. Rentschler. He's at a luncheon. Are you ready for this? He's at a luncheon in which Karen Reed's father is also in attendance. That is some shaky stuff. And so they think that further makes the relationship between the ARCCA experts and the defense team, and obviously the Karen Reed contingent, including her dad, what do they call it? Murky. It's now a much more murky relationship. So they want to bring that up. And if the defense is going to suggest that there is no bias, then the Commonwealth either wants that shut down or wants the ability to bring out these other issues. This is the old trial within a trial scenario. This one could be limited to some degree by the judge. We'll see. We'll see, because she is so tied up in knots about what she thinks is the issue between the defense and the ARCCA experts. I don't know. I could see her trying to shut down the whole topic. You're not going to defense. You're not going to talk about the fact there is no bias. Prosecution, you're not going to talk about some indication that there was bias. We're just not getting into it. Let these experts get on the stand. Let them testify to what they're going to testify to, and then let the jury do what they're going to do. All right. So we'll see. That one was just filed yesterday. That was the opposition. So whether we, I don't know if we're going to get to all of these tomorrow even, really. I mean, come on. They may have to squeeze another day in somewhere. Let's see. Oh, this one's a fun one. And I saw some people react to this one. This is a Commonwealth motion to exclude expert Garrett Wing. Okay. They may do their Garrett Wing research. On its face, the prosecution is saying, look, all we got was a CV, curriculum vitae, which is one of the things they should normally get. Let me check my phone here again. Hold on a second. I'm hearing buzzing. Okay. And they should also get any reports that an expert has prepared. And the theory is, you're not going to ambush the other side by just throwing an expert on there, right? So the Commonwealth is saying you can't do that because this guy, all we have is his name basically and his CV. He has no reports made. He's provided, there's no opinions provided. So we don't want this trial by ambush. And generally that is something the court tries to avoid. I'm not sure why they didn't provide any of this other information. Maybe it hasn't become available yet. Maybe this guy is going to be a rebuttal witness. So we're not sure yet. But that one is a new one on the calendar. I did a little research on Mr. Wing. He is a canine trainer handler. He was in law enforcement for 17 years, primarily in the canine unit and then also in a narcotics canine unit. So safe to say he knows his dogs, all right? And so we can only assume that he's going to be testifying as to animal behavior that might lead to the arm injuries. It's certainly going to be in that universe. But what he's specifically going to say is unknown. And of course, that is why the Commonwealth is all pissed off about that one. They would like to know what they're up against. And I admit, I don't disagree with that. I have a feeling, though, it is so premature in the process that designating him was far more important than fleshing it out with whatever the reports may be. And remember, that's a key part of any trial prep. When you disclose witnesses, and by the way, I did hear Judge Bev say she wanted witness lists by the end of today. So we already know of one witness list, right? one that has Aidan Kearney on it. So anyway, that's key, that if you provide the names of your witnesses, experts included, the sooner the better. And if they had not provided Mr. Wing's identification at the very least and his CV, then you could hear the Commonwealth saying, if they waited, let's say till there was a report or there was stated opinions, then the Commonwealth would be saying, this guy can't testify at all because you failed to disclose him timely. So they've disclosed him timely. And the question becomes, what's he going to talk about? So, okay, let me see what else we got here. Zepp says, any major developments? Well, I don't know. I think the most major development took place here at the Stoughton Courthouse, and that is that Turtle Boy Aidan Kearney is not back in jail. He is back home with his, or he may be eaten out. He may be eaten with the supporters because they all but hoisted him on their shoulders out here in front of the courthouse. So that was good news. Somebody says, let's see, the thing with these comments, I can read the comment, but the names are in either green or blue, and they just, the sun always wins. Let's put it that way. So I'm staring kind of into the sun. So I might not be able to acknowledge who says it, but I'll at least get the question to you. I thought she was going to remove Alan Jackson. See, that was the drama, the totally unnecessary drama, right? She sits there, she's huffing and puffing. She just like she did when she had her grave concerns. She didn't label them as such, but she's throwing words around like flagrant and intentional misrepresentation and candor, and basically browbeating the defense team. Okay, so she's hanging this ominous cloud over the proceedings right off the start, and then she starts talking about sanctions. So if you missed this, she calls the prosecution. She tells the prosecution, stay, good prosecution, stay, and she has the defense team, including Karen Reed, which is unusual to have the defendant herself, himself, come up to the sidebar. So they all come up to the sidebar, and she's prefaced it with this reference to sanctions. Well, we know that could be removing a pro hac vice attorney or more. Maybe she's got 3 of them. And we already know she didn't allow Mark Betterow in, which is outrageous, ridiculous, unfounded. But who knows what she's going to do? Or she could limit the ARCCA expert testimony somehow, or exclude it entirely. With this court, it's a mixed bag. Who knows what could happen? So they have the relatively short sidebar, and they go back to their corners. And she says that she's had a meaningful and important discussion with Karen Reed, and she wants all of her witnesses. No shit. She wants all her witnesses. Nobody's going to jump ship. So that was off the table. Everybody's clean. And then she really just kind of left it alone at that. So nothing happened. So for all of the bluster, all of the drama, all of the clutching of the pearls, nothing happened. And so Alan Jackson removed. Oh, we have weighing in from the peanut gallery here. Hey, great streaming partner, Michael Bryant. Thanks for picking this up today. Great coverage. I'll be on with you live at 5 to 7 tonight. Oh, okay. Time. All right. Let's see. What else we got in here? Okay, I can't put that on because I'm way too modest, so I can't put that one on. Okay. This is from the control room, getting some wind interference. The Starlink, which looks like it has a pretty darn good signal right now. I'm hoping it's not too much. Let me know, Missy, if it's too much, because I don't want to torture anybody. But the signal, at least from all indications on my end, look pretty good, and it's really not even all that overcast. So. I was talking to a number of the supporters who have seen our stuff and are very thankful that we're making the effort to be here and kind of find out exactly what's happening. Let's see. Supposedly the clip intimidated a witness, but Michael just explained. Oh, This is okay. Yeah, explaining my explanation. I like that. Sometimes, yeah, I need to do that. Okay, this is interesting to make account. If bail revocation last minute isn't considered retaliation, it was nice how Aidan's attorney pointed that out. You know, if we're going to talk intimidation here, how about dropping this bomb on us? You know, this sandbag. We're not going to do anything as of Friday. Oh, yeah, and today we're going for bail revocation. They consider the courthouse an ice cream parlor. Okay, man, I wish you hadn't said ice cream parlor because I'm kind of hungry. I really am. Let's see. Meredith, she seems very lovely. Great to hear from her. Yeah, I mean, I asked her, first thing I asked her was, you know, how you doing? You know, how you hanging in there with all of this? Because it's life-changing, you know, and she said it is, you know, she's looking forward to the day where we aren't coming to court every day. And we're not thinking about it every day. And she said she was a CPA, and I'm thinking, oh my gosh, April 15th is coming up. Occasionally I file my taxes. Then I learned she does more corporate stuff. And so 15th is not a big deal for her, but March 31st is, because, you know, corporations do quarterlies. And so that'll be the end of the first quarter. And that's, you know, like what, 13 days away. So she's grinding away at that. And, you know, here to totally support Aidan, which he's lucky to have her do. Let's see. If someone commits a crime, it's probable cause to arraign him, even if it's not a two-party state. Well, an arraignment takes place no matter what. And here's the different systems, and it gets kind of confusing at times. You have grand jury indictments. You can also just bring charges directly through the district attorney's office without a grand jury. In fact, I think the grand jury system is antiquated. It's dumb. That's my legal analysis. It's stupid. You know, you gather a bunch of citizens in a room, and they who have no legal background have to decide whether there's probable cause to indict. You know, the old "you can indict a ham sandwich" story. To me, it's dumb. And you get indictments on cases like these, you know, alleged witness intimidation charges because of the grand jury process. So anyway, anytime there's charges brought either by indictment or by direct charge from a district attorney, there has to be a formal opportunity to present those charges and take the plea. And that's the arraignment. So yeah, probable cause is a very low threshold, and the arraignment is really just the formal procedure by which those charges are told to you in open court, and you respond in open court. That's all it is. That's why in most cases, you'll hear the phrase waive formal reading of the That's done for a number of reasons. Primarily because the defendant never all of that dirty laundry repeated, because, you know, it's always written in a way that makes the defendant look like scum. So the defendant doesn't want that repeated, right? So we'll waive formal reading, and they're fast because of that too. Remember I couldn't believe this in the YSL case. The indictment was huge, right? And Ms. Love decided to read the entire indictment to the jury panel, you know, the pool. It took hours to read that. And of course, with former judge on the case, he allowed it. And, you know, that's very weird, very unusual. Now, in a lot of states too, you have a pre-trial, you know, preliminary hearing where you would find the same probable cause. It's a different process, different state. I just think the grand jury process is we're over it. That's all I could say. We're over it. Oh, really? Oh, Missy said at least it's not cold. Well, it ain't warm. Okay, I'll leave it at that. Let's see. Okay, let me get it. I'm getting more tech issues. Clear as long as it's been connected. Okay. And yes, Missy does an amazing job. She does an amazing job for the channel. There is no doubt about it. Okay, I'm getting the Dina word. She'll be over here in about 5 minutes. So let me see if I can pick up a few more questions or stray notes. I was in the hotel room last night just going over some of this stuff to see, you know, what I want to focus on, and because there's just not enough time. And every day there is so much stuff going on in this case. What is it, and I'm going to ask Dina this too, and it may take a while for her to answer, but what is it that really bothers you most about this case? I mean, there's so many things. What is it? If you know, somebody said you can only pick one. You can only pick one thing that totally ticks you off about this, right? Yeah, I don't know. I don't know what that would be. So let's see. Oh, Linda keeps popping in here. Linda, you're not going to go to the head of the line. Let's see. I was watching. Anybody watch the Glarer last night? I was going to be on there. It didn't work out. But Mark Betterow was on there for it seemed like 2 hours. Karen Reed popped on for a while, and Aidan came on a little bit later. I think they raised. I want to say it was something like $25,000. Is that not right? Somebody who might have been in on that. He did 12 hours on a Karen-a-thon, I called it. So God bless him. That is yeoman's duty, and it paid off, man. It paid off big. I saw some donations, like $2,500. I donated that for Linda Kenny Bodden on her behalf. I just spent her money for it. That was kind of fun. Let's see. Oh, here we go. Oops, where did I go? Is having Paul O'Keefe in the courtroom not defended intimidation? Remember all the glaring that was done? Not glaring. He arguably does the same as others charged in both in-person courthouse, television, or the web. Yeah, there's no doubt. It goes both ways. But will it be judged equally? Will both sides be treated equally? I haven't seen that. I mean, I feel sorry for the O'Keefe family. The death of Boston officer John O'Keefe is a tragedy. But the focus of a lot of that animosity, I think many people would think is misguided. I know who I'd be pissed off at. I'd be pissed off at the prosecution. I'd be pissed off at the cops who supposedly investigated this case, because if they had done so properly, maybe somebody else would be sitting there at the defense table, somebody that you could actually prove a case against. And I'm not, I'm not in the Free Karen Reed camp. I love a lot of these folks, but their position is different than mine. Mine is, you got to prove to me the case. That's my position. And if you can't prove it against Karen Reed, then she shouldn't be tried. I don't know what the hell happened, but I do know that the police could have done a much better job of investigating this case. Get 2 leaf blowers, get more Dixie cups, whatever you need. They could have done a much better job. They could have, go in the house. They could have gone into 34 Fairview. Never thought of that. They could have talked to and found the snowplow guy. So those are the problems. And that's, if I'm the O'Keefe family, what I am most upset about. I think they're kind of blinded because of their, connection to local law enforcement. And they're just caught up in the narrative. If we're going to get somebody, there she is. Some of these, you guys are crazy. Nosy Rosie. I'm also a transplanted Rhode Islander that defected to Connecticut for the sticks a dozen years ago. Worked in Norwood. And my ex worked for Microsoft in Canton. It's funny. I went by that building. I was driving around. I'm getting to know this area better than I ever thought I would. I've stayed at 3 or 4 different hotels when I've come up here, and I've definitely got a list. Only one that I would definitely not go back to, and I won't besmirch them. But the others have been great, and everything is very close around here. If you've been up in this area at all, to get from the Dedham court to here in Stoughton, it's 10 miles, but it's not exactly, super highway miles. So it took about 20 minutes in the middle of the busy day. But the hotels I've been at, then like 5 minutes from Canton, 5 minutes from Dedham. Just everything is very centrally located. So that's a good thing. Oh, it looks like school's getting out. The courthouse is right next to, let me see if I can gauge ages. I'm guessing grade school. Yeah, definitely a grade school. So if you see a lot of folks wandering behind me here, the school just got out at somewhere around 2:45, I suppose. And I'm also illegally parked in their parking lot because when I got here, all the other parking spaces were taken. So if I get hauled away, that explains it. Let's see what else we got here. So the plan is tomorrow is going to be just all out, chock-a-block with more motions in limine and more, pearl clutching and fretting by Judge Bev, I'm assuming. Because I think some of those motions, and Linda and I will talk about those when we come back at it later tonight, some of those are very important. We did a show that I think aired last night talking about how the decisions on those motions are going to shape and change trial number 2. And they have to do with expert testimony. They have to do with the substance of some of the expert testimony. Remember, every time the defense brings an expert along, either from the first trial or a new one, it is immediately opposed and attempted to be excluded by the Commonwealth. That's the dance in its extreme. I've never seen anything like it. And when you go into those things knowing that they're almost always denied for 2 reasons. Number one, as I mentioned before, these are witnesses that have something to help the jury understand the case, and unless they are just so totally irrelevant, they're going to come in, and it's going to go to the weight, not the admissibility. The other issue is motions in limine are not carved in stone. They're like chalk, and I don't mean the Massachusetts demonstrative evidence chalk. I mean, they're like chalk because they can blow away, be wiped away. During the course of trial, they are subject to being revisited, and quite often are. And sometimes something done by the attorneys in the cross-examination or direct examination of a witness blows that motion in limine ruling out the door. No longer makes it appropriate. And you'll see that quite often when you hear that phrase, "Your Honor, they've opened the door." Well, sometimes doing that will erase a decision that was made favoring one side or the other during the motion in limine process. Thanks, Michael Bryant. Distracting, watching my baby land in Vegas for all the real. Oh, okay. Yeah, well, this is not as weird as a Vegas show, but I don't know. At times it's getting there. Let's see. Did I do this one already? No. That scenario is no different than commercials on TV. If your baby consumed formula, you may be entitled to the following. Oh, I agree. Speaking of, oh, there she is. Hold on a sec. I was just going to tell a fascinating story that I'll just have to leave for another time. Remind me.
Fascinating story.
Yeah, remind me. Dina, how
What's
are you?
going on?
First of all, most important question: did you bring me a doggy bag?
No, we I rushed out. I wasn't even done eating.
Oh, we should have done that.
Well, that's all right. It's chicken wings. I'll get chicken wings again. But
so, reaction to today's activities.
Oh my God, I haven't even. I was live streaming with the streamer in the United Kingdom, so I didn't get to hear all of everything what happened, but I did know that the ARCCA guys are in.
ARCCA is in.
ARCCA. I got to try to say that. ARCCA guys are in, so that really made me really happy because you never know with Auntie Bev.
Well, you heard how I use that word exercised she was at first.
Yeah.
She was, the stuff you're saying is so intentional misrepresentation, flagrant violation, no candor.
Oh my, you want to wring her neck. I'm not saying that
in a nice way.
Yeah, in a nice way, because God only knows charges will come out. I mean, they're really playing around with everything. And I just don't understand how the world above her kind of they have to be looking at her going like, what are you doing? It's so blatantly obvious how much she hates the defense.
Well, it makes you wonder if those above, whether it be Morrissey or higher up, if they aren't condoning it.
Well, it's almost like they are condoning it because it's opening up Pandora's box. It really is. I mean, in my point of view is this corruption has been going on for years. And to me, it dates back to the Whitey Bulger days. And it's a lot of people's heads are going to roll because they've all dipped their fingers into Pandora's box. You know what I mean? And it's like, all right, so Bev's on the take with somebody else, Morrissey. Morrissey has some goods on somebody else. Somebody else has goods on somebody. So as you climb up the ladder of who's going to get exposed, the one above them is going to get exposed. And
It's got to stop
else.
somewhere.
It's yeah, but
who's the top? Who's the top?
Exactly. Are we going back to Deval Patrick days and everything? Like, I mean, Deval Patrick put her in anyways. So I mean, it's somewhere, somehow it's got to stop somewhere, but where that leads to, I mean.
Yeah, some people say the appointment process is part of the problem.
Oh my God! It's
why don't you just vote for judges here? What the hell's wrong with you?
You know, people got to go out when you have your small town elections, whether it's the school committee, you know, the planning board, select boards, mayors. It all makes a difference. I've been voting since I was 18 years old. My social studies teacher, shout out to Mr. Nuttall. I don't even know if he's still alive. He was a great teacher, and I was of age in my last year high school. I was 18 years old, and I was a terrible student. Let me just tell you.
Come on.
Well, I thought Arkansas and Arkansas were two different places, but
okay.
That's another story. But he encouraged me, really. We played games in his classroom, and he really encouraged me about town elections. And since the age of 18, I've always voted in town elections. No matter what election it is, I'm out there. And whatever someone needs a paper, whether I agree with them or not, they have the right to, you know, seek any type of seat that they want. And it's really important because you're seeing right now in the world is here in Canton, you're seeing what a school committee member can do, what a select board member can do, what a planning board, it's playing out live across the world right now. So your vote counts. Don't ever think that it doesn't. It does. And that's where it begins, is who's corrupting down in these smaller positions. And who do they know? Who is their cousin? Who is their sister? Who did their sister marry? That all makes a difference when it comes to all these laws being violated. So it's really important.
I say if you don't vote, you don't get to piss and moan.
Oh, absolutely. Right? You don't get to piss and moan.
Okay, so obviously in this courthouse behind us, some good stuff.
Oh my God, we were sweating what was going to happen today because we've seen the evil side of people that hold control over the laws here. And, I'm so grateful Aidan isn't in. Aidan has spoke out for all of us. He's representing all of it. And I really feel that's true journalism too, is what he does. Some people might not like the way he does it, but you know what? He's exposing a lot of stuff that has needed to be exposed for a long time. So I am so grateful he is not. They didn't revoke his bail.
I know he was, I talked to him this morning when they were still under the impression that it was going to be just pro forma, pop in, arraignment, and he's feeling pretty good, but you could tell, and he admitted, you never know until it happens. And then look how they sandbagged.
Oh my God. And to sandbag him like that, we find out bits and pieces as, people come out of court and everything else, but like to do that to Bradel, another lawyer, their brothers and sisters in, they have a bond, like I guess police have a bond, and it was off the table. And then all of a sudden it went back on the table. What a shitbag move, and we're talking about Cosgrove, who in one of Aidan's sessions, Cosgrove came in to give Aidan Bradel copies of text messages from the fake victim, like their cell phones. And he pulled it out of a smart food popcorn bag, like one of those giant ones from like BJ's. I almost fell off my seat in the courtroom. I'm like, here's this paid former judge, and he's pulling paperwork out of a popcorn bag.
Like a homeless guy.
Oh my God, you would have thought he was a homeless guy. And it's just, each time you come to court, you almost get a punch in the gut of how evil this really is. Right here in Massachusetts, it's a fight with good against evil, and they're trying to beat us down pretty bad. And we're Massachusetts people. We're in for the long haul.
Do you think that's why people have resonated to this case? It's like this Goliath, kind of problem here.
Well, there's so much to answer to that. People have known corruption's going on, and for a long time, and did we really know how bad it really is? People that are connected into the corruption here, some people know more than others, and we're finding out as time goes on how much corruption there really is here. And it's very sad. It's very frightening. People don't realize when any of the people on boots on the ground, for instance, we're out here, our faces are exposed. We get hammered out here and we have frightening things happen to us. They showed last night, Channel 5 did an interview with the Proctors. And, there's a lot of people in the world who are like, all those poor things, Michael Proctor did some really crappy stuff. And that's not how he should act when he took an oath. But not only that, is people in the movement, Lizzie Proctor called people's work to try to get them fired. Why didn't Channel 5 air that on TV? There's two sides, there's three sides to every story. Each side and then the truth in the middle. So each side has done stuff that's probably not colorful. And we all have to take responsibility for mistakes that we've made. But, the mainstream media just refuses to air both sides. And it's sad. You have to get both sides by going on social media and finding it. And thank God we have people like Tom CPU out there. We have Alternate Corner out there. They have the channel Resistant to Silence that I'm always on. It's the People's Channel. We're out there. And of course, my favorite, The Glare, he's out there doing it too. I mean, Melanie Little, you got Nurse Kim, you got Emily D. Baker. Like, that's where you got to get your information. And as well as you guys.
I knew you would get to Justice Serve TV eventually.
But I had to say a little bit to you, like you're out here now, you know what I mean? And you're making the time to talk to the people here that are fighting for everything. And we can't repay anybody, you guys, enough of what we're doing. How can we thank everyone for getting the word out there? It's important. This is an important fight. If we don't win this fight, I think we will in the end. But if we don't sit there and hang on it and put our dukes up and really keep this fight going, and we need everybody out there, this is never going to happen again. We're never going to have this opportunity to break the corruption that's here in Massachusetts. It's longstanding. It's been here a long time. And I want to leave the world a better place for my grandchildren. I don't want to have my grandson or my granddaughter drive down the road and possibly be killed or murdered and it covered up and not know what actually truly happened for them. And the most important thing is, whether you're out there and you believe whether Karen Reed is guilty or not guilty, let's put that aside right now. Take that. You should be outraged that the way the investigation went, there's possibly never going to be justice for Boston police officer John O'Keefe. And that should have everybody screaming from the walls.
That's just what I was talking about now. We were talking about, somebody had asked about Paul O'Keefe being in the courtroom and kind of mean-eyeing, some folks. And I said, if I understand their loss, and that's sad, I'd be mad at the prosecution. I'd be mad at law enforcement. Yeah. That's where I'd focus my anger. So let me ask you this. We're in Stoughton, another little case going on here. Give me your thoughts on that. Sandra Birchmore case.
Disgust, absolute disgust that a woman, and she was a woman now when she was murdered, but as a child, she looked up to law enforcement, and you want to trust them and everything, and to have her, I'm losing my word that I wanted, to have her schooled. I don't even know what to call it, and sexualized like that by people that are supposed to be trusted in a program that is worldwide.
So this is for those who don't, the two people that don't know. Sandra Birchmore obviously was an explorer. I think that's what we would call him.
Program.
Right, with the police, and became friendly with an officer and had a relationship with that officer. And then at age 23 was pregnant and killed herself. That was the original determination by the medical examiner, correct? Suicide. Yes. And then along came a civil family investigation with Linda Kenny Bodden's husband, Dr. Michael Bodden, who determined that you're nuts. This is, this is a medical term. He said, you're nuts. He said, this was not suicide. And then the feds got their own expert who basically came in and came to that same conclusion. Where's that case now? Do you know?
Oh, look at how quiet it's been.
Very.
It's very quiet. The officer, you see, I'm so nervous. I'm forgetting words. Hartwell.
Yeah, you're nervous. She's just so shy.
It's sort of like quiet. So is he dropping names? What's going on? Are they putting it off to, because it all has all of these cases have connections. And it's like they keep putting stuff off to see what happens with the next case. And people, I mean, we have a lot of people down here for the Karen Reed case, but, you know, Mizzy is still out there fighting for Sandra Birchmore. And right now, it's just like they keep on postponing court dates and stuff. So it's right now, I'm not 100% up on exactly where it stands. He's going to court soon. But I think, I mean, is he spilling the beans?
I always get his name is Falwell, right?
Farwell. They keep on putting it off. So we don't know. This whole federal investigation, like you can't get answers. I even called the FBI to, like, the day that Brennan said.
Did you ask them nicely?
I asked them nicely. I even gave them my name. I mean, they have a file on me already. So I gave them my name and I'm like, look, I was just in court and I would like to know, is this case closed? Like, if it was closed, you think they would say it's been closed, but it's not. They won't give any comments. So
how come everybody's saying it is? They're saying it's over, it's done.
Who's saying it is?
Well, yeah.
Rafferty that writes notes on Post-it things and says
That's the police chief. That's the Canton police chief.
And
I've never seen her. Is she a real person?
She is a real person, and she's got. If you've ever seen a killer's eyes, and they got those beady dark
They have
killer.
no pupil, just like black eyes.
Helena
Wow.
Rafferty, and she has an air about her. You know, like I have no respect for her at all. I just don't. She's going to end up going to jail big time. But it just seems, you know, all these cases have all the same players, or a majority of the same players, and it's just frightening how much stuff they're getting away with and how much the court system is just putting stuff off. You know, what do they call it? The wheels of justice spin slowly. Well, jeepers,
Grinding
my God.
over people.
Yeah, they're grinding over people. Exactly. It's just, it's, you know, we're in here for a fight, and we're never going to give up what we're doing and exposing this stuff. But, you know, I wish the FBI would throw some breadcrumbs out to us, you know. I really do, because it inspires us and give us hope. But the investigation, just because I've said it before, just because one door closes, if it's true, it doesn't mean that one closed door didn't open three more. They could possibly be done with the investigation. And the investigation they were doing was an investigation of the investigation. Right. It wasn't an investigation into John O'Keefe. It's an investigation of how the investigation went into John O'Keefe's death. Boston police officer.
And that's why Elizabeth Proctor was so out front about, you know, John Proctor's been just, you know, beat up and it's unfair. And now this investigation has cleared him, basically, is what she's saying.
Yeah, she can wish it. You know what? He did this to himself. He completely did this to himself. His words, his actions, all of it. I don't feel bad for him at all. What he did was deplorable. When you take an oath of office, you are held to a higher standard, and he broke every rule there is, every rule. So I don't feel pity for her. I don't. She should have left him a long time ago with what is any sane person looking at this would be like, that's my husband. Like, what are you, out of your mind? I wonder how her mother feels about it, if her mother's alive. But how do you, or her father feels about a husband talking like this that his daughter's married to? Like, it's disgusting. He's disgusting. He broke an oath.
Think he'll testify?
I don't know if he's got the balls to testify.
Okay.
Honestly, because things are going to have to happen. And with this next trial, they're going to impeach themselves. Their stories are going to change because they're all covering. We don't know who's talked, who spilled beans, who's done whatever. But
that would be so dumb when you have testimony from trial number one. If you stray from that very much, it's going to come back and bite you in the ass.
They're that dumb to have that bite them in the ass, and it's going to. But not only that, the second trial, I think a lot more questions and stuff is going to come out in this one, and it's really going to bury them. They did a lot of wrong things here. A lot of wrong things.
Usually we see in a retrial, things get tightened up, you know, just by most of the time, you know, either witnesses are either, you know, there's less you need from them, or you even dump witnesses. I get the feeling this was going longer than the first one.
Well, to be honest, I'm just praying that we all know what the weather was, so they can cut that whole 2 weeks worth of weather out. I think there's going to be a lot more hot.
The ground was hard as a rock.
I know. Oh my God.
You didn't know that before.
Well, yeah, I apparently know now. But 34 Fairview, like if you look at all the video that the prosecution showed, like pictures and stuff of 34 Fairview, you think it's like a football field out there. It's a tiny yard. I encourage anyone in the area, go drive by it.
Go knock on the door of the new owner.
No,
So
don't
they'd
knock
love
on
to
the
see
door.
you.
They're very nice people.
Are they really nice?
Yeah.
I felt sorry for him because of this whole thing.
They didn't even know about it. But when you drive
I've been there, and
you
I
drive
call
by
it
and you're
normal.
like, oh my God, like where John's body was, how could you not see that? Like it's just,
Unless you're blind, drunk, perhaps.
And the way the road is, lines and stuff, there's no understanding. And I don't think you get a true understanding after what the prosecution showed in court. You were like, well, maybe they didn't see a body or whatever. There's no way Lucky Loughran would have not seen that body. And kudos to Lucky Loughran. What a decent man. What a decent, hard, blue-collar worker he is. He knows his job. He knows it inside out. And he got up there and told the truth. And kudos to him. I think they were going to try to blame it on Lucky. I think whatever happened, they were going to just toss John's body out in the, front yard and be like, oh, Lucky, he was drunk and Lucky must have hit him. Right. And they never accounted for how that scenario was going to change.
It's important you mentioned the, the spatial orientation, and they had the jury view the first time and they had the car parked out there. But now, and Lally was okay with that, right? Mm-hmm. They had the car parked on the curb somewhere near where it might have been. Of course, it was, blazing sun and not anywhere near the same conditions. Now the Commonwealth says we're okay with the view, but we don't want the car there.
Yeah.
What do you think of that?
I don't know, because if you remember from the first trial, when they had the viewing, Lally had said something to like the jurors, like, or somebody like, make sure you look at the console or something like that. Like, so I don't know, bring the car in. If you have the truth on your side, you shouldn't have to worry, but here in Massachusetts, you do a little bit. But if you have a firm believer that the truth will set you free, the truth is going to set Karen free. So bring it. She's very confident in everything that she talks about, and she's not afraid for the stuff to come out. You know what I mean? So I bring the car, bring whatever Spanky thinks he wants to bring it on, Spanky. The defense is there. The defense is ready. There's a great team behind them. I mean, Alessi's unbelievable. You got Weinberg in court with the appeal. I mean, you got Yannetti, and Alan Jackson's just amazing. So, and Liza Little. Let's not forget Liza Little.
She had a big day today.
Oh, yeah. Liza Little is just so much respect for a woman, and they're fighting for that. And then it goes to show with Karen too. The women in this whole entire case, other than Bev Cannone, the women in the movement, the Karen up there, her parent, her mom and stuff, are very strong individuals, and it's showing the world how strong we can be. But bring it all on. We'll combat whatever you bring at us.
One thing I've noticed is the prosecution wants to limit stuff, a lot of stuff. Like defense, would you just plead guilty and we'll get over this whole thing? They want everything out. It's not really a good way to educate a jury about a case.
Well, you're going to see a whole different kind of game being played this time. Spanky's really trying to just do everything he can to just no stops out, and the defense is just coming back like, okay, here's this, you know what I mean? And it's a fight, and I'm not afraid. I want it. We're going to trial. Let's go to trial.
I mean, it's an adversarial proceeding. That's how the truth is supposed to come out, right?
Yeah. Well, it makes you really wonder about our whole judicial system now. I'm not the brightest bulb on the block.
Oh, come on.
No, I really truly are. And we learned the Daubert hearings, I call them the doobie hearings. Like, why doesn't everyone smoke pot and just talk about it with everybody? And then you got the hearings, motions and lemonade. It's like more lemonade. Like, we're making up things to this because, you know what I mean? It's a learning lesson for all of us. I never paid attention in school, and I've really never gone through the court system. So everything, it hits you. I find myself Googling, what is this? So
you know more about Rule 14 than I'll ever know.
All these rules and everything, it's just mind blowing, but it's teaching the world a lot to pay attention. And it's every time something happens, it's a learning lesson.
We appreciate you being out there. And are you going to be there tomorrow? You are?
I can't be there
Oh,
tomorrow.
I can't be there either.
I have work. It isn't like the last thing. Believe it or not, the world thinks that we're all jobless and scumbags and we're all on welfare and all this other stuff. We're former drug addicts and everything else. Make up all the lies you want. The last trial, I was out because I have four herniated discs in my back, and I was in the middle of getting treatment. So I was afforded the time to be out there every day. This time I'm not. I'm up back at work. My treatments are all done. And I have to limit my time. I took today off, used some of my sick time and vacation time. And so I have to be sparingly with it. I will end up when and if the trial starts again, I will be part of the afternoon crew instead of the morning crew.
What do you do? Can I ask?
I open the gym for Planet Fitness.
Oh,
yeah.
All right.
So I have to get up at like 3 a.m. to get ready for work.
Yikes.
Yeah. So, and I work till like noon time. So I'll get out at noon. The courthouse is only 20 minutes away. Traffic shouldn't be too bad. So I'll buzz right over there and be part of the afternoon crew this time. But we ain't got no quit. We're in it. And I just want to say to everybody out there, whether you're boots on the ground out here, it doesn't matter. The people that are out there watching from other states and everything, we need you guys. We need you guys to keep on putting everything out there. We need people like you that are coming out and willing to talk to us and not portraying us as crazy individuals like they try to. And another thing is, this movement is not anti-police. I want to get that right. I actually worked for the police station for over 10 years. I was a matron. We're not an anti-police movement. I respect the police, but I respect the good police. I don't respect the corrupt police. And there's a huge difference. So please hammer that out there, everyone. It's not an anti-police movement. And just stay strong. We got Sandra Birchmore. We got Enrique Delgado Garcia. And there's more people. There's more. And it's all going to come out. Let's just pray that good triumphs evil.
As I've said, for you guys, it's like there's a major disease, and Karen Reed is a symptom, right? Okay, so glasses. You get a lot of feedback on the glasses.
I know
Before you get out of here. What do you
it's
think?
gone crazy. All right, so listen.
Selling those.
I think they should sponsor us and give the money to Karen Reed, but it happened. I'm Italian. All right, folks, I'll show you guys. I have big dark bags and circles under my eyes. So when people see me or take pictures, it comes out in pictures like someone punched me in the face. So I started putting these little reading glasses on so that if you're looking at me, like you don't see my Italian eyes. And it's gone on this like craziness about the glasses. You know what? If it makes someone smile, if it makes someone's day, and whatever, it is what it is. I think it's hysterical. I mean, the dogs are wearing them, people are pulling up, t-shirts are being made now. So Kathy O'Grady's going to be selling t-shirts, and any of the money 100% goes to Karen Reed. So if it's a little bit of a week or two of blue glasses and it makes people smile, let it.
Good for you. Yeah.
It was a pleasure.
Oh, I'll see you around now.
We'll see you around.
We'll be chatting.
To everyone out there, keep us in your prayers for us to stay safe, especially Karen and her team. And we're fighting the good fight for everybody out there. So thanks for your support.
Okay, what'd you have for lunch? You had the wings?
Buffalo chicken wings. You can't smell them on me?
No.
I had buffalo chicken wings. They were
Okay.
really good. They're really good down at Crisp's down here. So the gang's all there.
Okay.
We always try to go to local businesses and wherever we are to sponsor local businesses and visit them and everyone's been so hospitable. It really has been.
I mean, you guys are known, right? I mean, people know.
Yeah, usually, I walked in today to the restaurant. I got my free Karen Reed shirt, and on the back it has everybody, Sandra Birchmore, John O'Keefe, everybody. And a guy goes, you guys are really serious about this. He goes, like, I give you prompts. And I was like, yeah, we're fighting the good fight. And that's what we're doing out here. And I just want to say before I get up and walk away is, let's not forget Boston police officer John O'Keefe. He is always in our thoughts, and we're fighting to get the truth about what truly happened to him.
Great.
So thank you.
Thank you again,
It's been
Dina.
a pleasure. Stay warm.
We'll see you next time. All right. Okay. All right. Always fun. Always appreciate chatting with the local folks. She is one of the most vocal but also one of the most fun. Okay, I'm going to get out of here because I'm going to rally and I'm going to go get something to eat. Maybe I'll get some wings. And then Linda Kenny Bodden and I will regroup. And at 5-ish, we'll do something. I'm thinking, I don't know, maybe a different location. Maybe I'll do it from the wings place. I don't know. But we appreciate you joining us here at Just to Serve TV, trying to bring you the whole story. You make up your mind. We just want to see the right thing done. And at this point, it's a challenge, I will say, for the Commonwealth, because doing the right thing seems to be maybe outside the norm. I don't know, just my impressions of this particular case. So anyway, again, Michael Bryant here. Thanks for joining. I'm going to bow out and appreciate you being here. I will see you again a little bit later on tonight. Linda Kenny Bodden and I will bring you all up to speed on where we are and where we're going.